Good afternoon, all. Welcome to the Appellate Division, First Department, oral arguments for today, May 2. So please ask for the time that you need to get out the salient points of your arguments. Please know that we have read your briefs. We are fully familiar with your arguments. So please, again, just ask for the time that you need to get out those salient points. People v. Rosio Alam. 525, Caman Metals versus Macquarie Futures.
Appellate, request 6 and 2.
Respondents request 5.
525, Matter of Our Children. That matter is submitted. Smartmatic v. Fox Corporation.
Appellant request 5 and 2, Your Honor.
Respondents request 5, Your Honor.
5, 2, and 5. MREF REIT Lender 2 versus RPG Maiden Holdings.
Appellant request 6 and 4, Your Honor.
Respondent request 7.
6, 2, and 6. Sternkoff v. 395 Hudson, New York.
Appellant request 5 and 5.
525. I'm sorry. Okay, so we need to get everybody together. We have Steinkoff is requesting 5 and 2. Who else do we have?
I'm the appellate. I'm not certified.
You represent, I'm sorry, you represent whom? Okay.
Respondent Park Plumbing requesting 5 minutes. 4 minutes.
And who else we have? Okay, so we have Sternkoff, 5 and 2. We have Fitzgerald, 5. We have plaintiff respondent, 5. 395. 2 minutes. And right, so what did I say? I said 5 and 2? Right. Okay. As long as that's agreeable to you. And then the other one was Park was the last one? Park Plumbing, 4. And who are you? Art Products, 2 minutes. Are we good? What do we got? For you, defendant. Okay, we're slightly over, but that's okay. Thank you. Now, People v. Anthony Strickland. That matter is submitted. DC or Decease Rising Up versus New York City Districting Commission.
Appellant request 6 and 2, Your Honor.
6, 2, and 6. Bello v. New York City Health and Hospitals.
Third party defendant appellant, New York Presbyterian Hospital request 7 and 2. City respondent request 5, Your Honor. Plaintiff respondent request 4.
Dr. K, 5 and 2. NYP, 6 and 2. City, 5. Plaintiff respondent, I'm sorry, how much did you request? 4. Thank you. On that matter, by the way, Justice Gesmer is recused. If there is a tie on that matter, then we will vouch in another justice. NYU versus the City of New York.
Appellant request 5 and 2, please.
5, 2, and 5. Board of Managers versus 56th and Park.
Appellant 5 and 2.
525. NASA versus Macy's, Inc. 534. People v. Roland R. That matter is submitted. First Commerce versus St. Mark's Property. That matter is submitted. Flowers v. 73rd Townhouse. 424. Again, the time that is granted, please keep in mind that is for you, not for us. If we do in fact have additional questions, and which requires additional time, they will certainly be put to you. First matter for argument is People v. Russell Alam. You may proceed.
Good afternoon. Karen Brill with the Office of the Appellate Defender on behalf of Russell Alam. In the 7 years between Mr. Alam's offense and the SORA hearing, there were three...
Bring the mic closer.
Oh yes, apologies, it's better. There were three pivotal developments in Mr. Alam's life that are nowhere to be found in the RAI. He was diagnosed with multiple sclerosis. He achieved mental stability after years of psychiatric issues that were linked to his past misconduct. And having been essentially alone in the world since he was a teenager, he reconnected with a strong family support network.
With respect to his MS condition, when he went to the hearing after he was initially diagnosed a number of years earlier,
Yes.
he fully was ambulatory. He didn't come in a wheelchair or a cane. In other words, he didn't present with physical signs that would suggest that would be an important factor for the court to weigh in terms of his recidivism.
He walked the relatively short distance from the back to his seat. Counsel made a record that he still used a cane, but that he had lost his and corrections was still getting a replacement together. Counsel, in their sworn affirmation, also made a record of his then present symptoms. That's as of the SORA hearing. That included pain in his right side, tingling, numbness, difficulty walking long distances.
So was any of this documented? Were there any medical records or anything from the medical personnel which would substantiate these symptoms of these issues?
So there were documents of his initial diagnosis and the fact that symptoms had persisted for some time past treatment, and then counsel submitted a sworn affirmation as to his present symptoms, and as the Court of Appeals...
The sworn affidavit from whom?
From counsel, sworn affirmation from counsel.
Counsel. Was there anything from a physician, from a doctor, who stated anything concerning the defendant's condition?
Not past about a year after his diagnosis.
And is there anything in the record or that was presented to the court which would correlate or show that the MS would in any way affect his, would in any way speak to his reoffending or anything of that nature?
Counsel relied on People v. Williams, which was this court's decision that discusses that a decline in mobility after the offense is a factor that reduces risk of sexual reoffense. And I think that's appropriate here. You know, Mr. Alam, because
So the answer to the question is no.
in terms of scientific...
Right, or no, we don't need any evidence, any actual evidence. But the answer to that question is no. It was just based on legal argument, correct?
Again, counsel did submit their own...
Is that
sworn
correct? Was that
affirmation.
answer yes?
I think the answer is no, because Mingo has held that sworn documents can be considered evidence, and counsel's affirmation as to his present symptoms was sworn.
Counsel's affirmation as to present symptoms is based on what?
On their information and belief as they swore under penalty of perjury.
Information and belief from whom?
That I believe Mr. Alam and the review of the full medical
Mr.
record.
Alam, who is the defendant. Is that correct?
Yes, and I think
Is there anything from a doctor or physician or anyone who has any medical expertise who could speak to this disability by Mr. Alam, and therefore why there should be a downward departure?
there wasn't here. I would also ask this court to look at the other factors, which included the ample documentation as to his present mental health.
How, in addition to these three things that you want us to take into consideration, how should we take into consideration his refusal to engage in sexual offender groups and to take responsibility for his actions?
I think that's a valid consideration. It's one that's captured by the RAI, and so What we're
That's a
ask-
what type of issue? I didn't hear what you
Sorry,
said.
it's a valid consideration, and it is one that is captured by the RAI. He was assessed points for not doing so. What the departure framework asks this court to do is to look at what's not captured by the RAI and factor that into the totality. Here, his mental health history is nowhere in the RAI. Mr. Alam had a clear past record of psychiatric issues that were linked to his sexual misconduct, and then he had achieved, during this prison vid, he did intensive psychiatric services, and OMH credited that he had achieved mental stability. And then during his entire 7-year prison bid, there were no further issues of sexual misconduct. So there was strong evidence that there had been a link that had been severed.
I'm sorry, counsel, did you say that during his incarceration, there were no instances of sexual misconduct?
On
'Cause
this,
I thought that there were 2 disciplinary violations precisely for sexual misconduct while incarcerated.
exactly. So that was on a prior bid when he was having
That was on a what?
a prior, after a prior prison sentence, not on this case. And that was during a time in which he was experiencing severe psychiatric distress. He was actually committed to OMH for months at a time. During this sentence, when he was serving this sentence, he received renewed psychiatric treatment, and during this sentence, he had no sexual misconduct tickets. And so I think that difference is actually evidence that once his mental health was properly managed, that concern about offense completely dropped.
So counsel, is there any evidence that his mental health wasn't properly managed the last time he was in prison?
I think the fact that he had to spend months in OMH's facility suggests that he was still struggling severely with mental health issues.
Well, but that's the same exact thing that happened during this incarceration, right?
No, Your Honor,
So-
he received outpatient services, including counseling, but he was never committed during this prison bid.
And so there was no, and also I just want to raise that there was no points assessed for his living situation and his employment situation, right? So those, to that extent, the fact that he's reconnected with his family was taken into account by the RAI, correct?
I would disagree with Your Honor. The guidelines on that point do not speak to family at all. They speak to whether someone is being released in a place where they have access to victim or a likelihood of detection. They don't speak to what it's like to have people who are looking out for you, who are invested in your well-being for the first time in his life as an adult.
Okay.
Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the court, Andrew Chung for the people. I'd like to take a step back and just analyze this from the factual pattern. The defendant, after being invited into an apartment while delivering a pizza, sexually assaulted an 11-year-old girl multiple times within the span of 20 minutes. First by groping her breast and placing his hands into the waistband of her pants, and then by kissing her and sticking his tongue into her open mouth.
Counsel, we're fully
Your
familiar
Honor.
with the facts.
Yes, Your Honor.
So, counsel, to the extent that it is conceded that the defendant refused to participate in sexual offender treatment, does the record show that the defendant participated in any mental health treatment that would be useful for our consideration?
Your Honor, the case summary, I believe, shows that the defendant engaged in some sort of psychiatric evaluation, and I believe those medical records are in the document as well. But as far as the sexual offender treatment goes, there's certainly nothing in either the case law or the record in this case that suggests that the court or the SORA court couldn't consider the fact that the defendant hadn't engaged in sex offender treatment as one of the totality of the circumstances when analyzing the defendant's argument for a downward departure.
Counsel, is there any evidence in the record other than an affidavit from an attorney without personal knowledge of the facts that somehow would say that this person who was diagnosed in 2016 with MS has less of a proclivity, I guess, for repeat sexual offense?
No, Your Honor. We would argue that it's not, because it's not sufficient that a defendant just prove that they have some sort of debilitating illness. As this court knows, the defendant also needs to show that it lowers their risk of sexual reoffense, and here the defendant has not done that. As the defendant's own trial counsel stated at the SORA hearing, I believe it's at the SORA hearing, MS can wax and wane over time, and so it's not dispositive as to whether the defendant was facing certain symptoms.
Right,
5
so
years
we
prior.
agree that there's the fact of the diagnosis. I'm just trying to get it. There's nothing else in the record from any mental or health professionals or MDs or any people with medical training or medical knowledge supporting the idea that this would lower his recidivism possibility.
That's correct, Your Honor. There appears to be no third-party information attesting to the fact that the MS is causally related in some significant way to his sexually reoffending. And I would also point out, Your Honors, that this isn't a case where the defendant used physical force in order to overpower the victim. The defendant committed the sexual assault while sitting down on a couch. And so even if it could be proven that the MS lowered his physical abilities, it wouldn't really be relevant here. And Your Honors, I would also just like to touch on really quickly the fact that the SORA guidelines are not just about determining a defendant's risk of recidivism. It's also about determining the gravity of the harm that would result if the defendant did, in fact, reoffend. As the SORA guidelines point out, certain defendants have a high likelihood of reoffense, but the gravity of the crime is comparatively low. The example used in the guidelines is forcible touching, perhaps on a subway car. In cases like this, where the defendant, regardless of whether or not their recidivism rate has decreased, and we would argue that it clearly has not proven that it has, the gravity that would result if the defendant were to reoffend here is huge, and the guidelines know.
Let me ask you, please, what is your response to counsel's argument that the defendant's reconnection with his family should influence our decision as to whether to order a downward departure?
Your Honor, similar to the MS argument, the defendant has not adequately demonstrated that a renewed family relationship is somehow has a nexus with their sexually offending behavior, such that if one goes up, the other will go down. I would also point out that although the defendant states that his family will assist him in things like finding a job when he gets out, I'll note that the defendant committed the instant crime while gainfully employed and while on the job. If there are no further questions, Your Honors, we would rest on our brief and ask that you affirm.
Thank you.
Thank you. I just want to note with regards to the multiple sclerosis, in Williams, there was no third-party medical testimony as to the effect of that physical condition, but it was a common sense argument that he was less mobile. And in this case, Mr. Alam is subject to SARA, meaning his housing will be nowhere near children, and he will just have a more difficult time moving around the city. His overall mobility is weakened now, and that makes his risk of reoffense lower than it was at the time of the offense. And I'd also just note, I didn't mention earlier, there was also documentation as to him qualifying for medical housing as of his release, and medical housing requires a disabling condition. So that was as of the SORA hearing. With regards to the Judge Gessmer's question about the mental health records, there is, the case summary talks about him receiving intensive services during this prison sentence, and also the parole documents submitted by counsel said that he would be connected to further mental health services upon his release. So there is documentation in the record that suggests he was continuing to receive mental health services that would help him ensure that stability lasted. The last thing I wanted to just say is to zoom out about what the ask is
Counsel, you're saying that there is in the record proof that he received some type of mental health treatment?
Yes, the case summary says that he received intensive services.
And over what period of time, please?
That's not in the case summary. Counsel submitted OMH records from about 2016 to 2018, and then the parole documents are as of 21, saying he'll continue to receive services upon his release. So the fact that he was referred by OMH at the time of his release suggests he was still under their care the entire time. Just to zoom out briefly about what the ask really is here, Mr. Alam will be on SORA for his lifetime. He has a lifetime designation. He's subject to SARA, and he's subject to PRS. A downward departure does not mean that he would be, getting off scotch-free here. It just says that given that if you look at the RAI, you see none of these pivotal changes in his life, the RAI did not accurately capture who he was at the SORA hearing, and so a downward departure is needed to do that. Thank you.
Thank you. Caman Metals versus Macquarie Futures.
Paul Sharkazy from Tannenbaum, Helper, and Syracuse and Hurst. Good afternoon, Your Honors. With your permission, I'd like to have Daniel Schmickler from the Illinois State Bar, who's been admitted pro hoc vice, to the argument on behalf of Caman Metals.
Yes, thank you. Proceed.
Thank you.
Good afternoon, Your Honors. Daniel Schmickler for the appellant, Caman Metals. Your Honors, this is a case that's here because it was dismissed on the pleadings and should not have been. The subject agreement that's the subject of this lawsuit was a negotiated, specific, written agreement that expressly received the approval of the global management of the defendant and met all of the requirements of a contract. Not surprisingly on these facts, there's a lot of avenues that are viable here for relief, and we've stated claims under each of them. The first, of course, is contract. We've met all the elements here. The only real dispute is the question of consideration.
Well, you don't need consideration for modification.
Absolutely correct, Your Honor, and that is definitely true. As a modification of a
And that's
contract,
the threshold question. Is this a new agreement or is this a modification of the prior agreement?
I think we plead this in the alternative. I think logically it sounds more like a modification, but we think it also could stand as an independent contract, Your Honor. Whichever way you'd like to reverse, we'll be happy to
Okay,
take it.
assuming it's a modification, why would it be a modification?
Well, because, Your Honor, the subject matter of the underlying customer agreement, which is a form agreement from Macquarie that the parties entered into many years beforehand in a previous engagement, is how this account is going to be handled. The June agreement that we've alleged in the complaint is the same subject matter. It's what discretion can be applied and what discretion is not going to be applied going forward for the next few months until these calls are expired. And on that ground, the terms of the agreement are that Caman is going to meet what was an elevated margin requirement, at least temporarily. It was going to close its puts, which, as we've explained in the briefs, and I can happy to address in front of Your Honors, was not something that Macquarie had complete discretion to force at that time, especially after it had already received an increased amount of margin, and that in exchange, the margin multiplier was going to be restored to what it was prior to the increase, and the calls were going to be held until expiry, meaning
So the emails, the June 2021 emails constituted a modification.
Correct, Your Honor. That's correct.
And what's central,
June
from
17th.
what I gather, would be that the defendant had the right to unconditionally terminate, whereas there were conditions to be met to exercise that discretion in the customer agreement, correct?
Well, I think it's a little bit more complicated than that, Your Honor. It's not totally, the defendant here had a lot of discretion. They had a tremendous amount of discretion, certainly with regard to margin funds. That's a separate provision of the contract. But if you look at the remedies section of the contract, if they want to actually close positions, there are 5 prerequisites, one of which must be met. I think it's clear from the allegations of the complaint.
Counsel, looking at the customer agreement, that's what you're talking about, right?
Correct,
The
Your
one
Honor.
that was accorded in 2014. With respect to the 5 criteria that would allow the termination, let me see, the closing out of the account, did your client comply did your client violate any of these? Because I'm looking at A, and it talks about the account did not contain the margin requirement required by Macquarie, but your client put up $2 million. So was that in satisfaction of A? Is there something that triggered
Your Honor, no.
the ability to close out the calls?
To be fair, on this record, certainly not. I think the complaint actually contains allegations that would cover the first 4 of these preconditions. The 5th one is one that's not addressed either way, but the facts, I would really say that if Macquarie wants to say, well, we had the right at that time under this agreement to close those puts, they're going to need to plead that. And of course, they haven't done it because we're on a motion to dismiss here. We haven't heard anything from them. We haven't seen it. There's no response to pleading. I would say that they're going to have to show that. The only question is when you look at our complaint.
Wait a second, let me just ask you something, counsel. Doesn't the document show it?
The document shows that Macquarie.
They had the right to, if they felt they were worried, they had the right to close the puts, right?
If they, in a reasonable.
Right, okay, so there's, all right, so that's your save,
And I would
right?
like to
Is that
emphasize-
they've got to at least plead it, and you've got to have some discovery whether or not they did it in good faith. All right.
Absolutely, Your
fair
Honor.
enough. Fair enough.
The one point I would just add to that is remember, my client made the margin requirement at that time. So they've received extra margin.
But it doesn't matter. 2 months later, they could have said, I don't feel secure, I'm closing it out. As long as they did it, in a reasonable way with a reason, in a reasonable belief, you're out. But I understand your point.
Great.
It's not pre-answer.
Thank you very much, Ron.
Good afternoon, and may it please the court. My name is Rachel Goldman, and I represent the respondent Macquarie Futures in this case. Respondent respectfully submits that this court should affirm the trial court's decision dismissing appellant's complaint in its entirety. The trial court...
Counsel, if we look at the June 17th email from Mr. Coates, who's, what was he, a senior vice president from Macquarie, how would you characterize this email? It has terms, it's responsive to the earlier text between the parties, and it has a bunch of conditions that were approved by global management. It's also signed. So do you see this as a modification? Do you see this as a contract? Or did you see this just as, hello, how are you? It's a communication.
It's a communication, it's a courtesy to a customer. This is not a contract. This is not a...
When you say it's a courtesy, are you referring to it as the trial court did, as an accommodation?
Those words, I think, are somewhat interchangeable. Accommodation, a courtesy. This is an exercise of Macquarie's discretion, which has already been noted is broad, and it is Macquarie's discretion alone to exercise. The question of whether or not it needs to be reasonable, there is a provision in here that says it needs to be reasonable, but it's still Macquarie's discretion alone.
But it's, so if it's not that's not a motion to dismiss, right? Because it doesn't, the contract itself doesn't completely preclude any claim, right? Unless you're saying that because you feel it's reasonable, then it is, which I don't think our case law would support.
Well, I would disagree with that, Your Honor, because
Okay,
the
you
language...
told me where there is a case where the contract is required that the action be taken with reasonableness, where on a pre-answer motion to dismiss, the issue of reasonableness has been determined. What case are you speaking of?
So,
just...
I don't have a specific case.
There you go.
But
You
I
don't
need,
have a
but
case because there aren't
No,
any.
I'm looking at the provision of the contract, which says if at any time, and we go to E, Macquarie, in its reasonable discretion,
100%.
considers it necessary for its protection, it may, in its sole discretion, take any of these actions to protect itself.
Again, that doesn't, on a 3211A1 motion, resolve the issue of whether you used reasonable discretion in closing out the provisions, does it? The contract itself doesn't resolve that issue.
Well, it does and it doesn't, and I'm not trying to be difficult, but first, there's no claim in the complaint that reasonable discretion wasn't exercised. That was raised on appeal.
Oh, it's a breach of contract claim, right?
But
So-
it's nothing about reasonable discretion. But if you look later in this provision, it says the above remedies are solely for Macquarie's protection, and any non-resort or partial resort to those remedies shall not relieve the customer of any of its obligations under this agreement or give rise to any claim against Macquarie by the customer. So at the time that this email was sent, there was no mechanism in the contract for the customer to disagree, to dispute, to refute, or challenge Macquarie's discretion. Does that mean later a claim might not be able to be brought? Of course, you can always bring a claim. But there was no opportunity at this time, there's no negotiation, there was no dispute. And there's no claim that this wasn't reasonable at the time. There's no challenge. There's no negotiation here, and...
Well, how do you say there was no negotiation? There was back and forth. It was, we proposed that this be done, and then you came back and said, following our discussions yesterday, so there were discussions as to a new course of action. Following our discussions yesterday, I have received approval from global management as follows. So why does this email not show that there was in fact negotiations and that there was now a meeting of the minds, for a better phrase, as to what was now going to occur?
This was, from our perspective, a directive, and a partial exercise of our discretion. The customer wanted whatever the customer wanted. It's not clear from this or the text message. None of that information was attached to the complaint, just this and the text message. And Macquarie comes back and says, this is our discretion to decide, and this is what we will allow.
So counsel,
But
you're
once you
leaving.
allowed that, weren't you modifying the underlying agreement?
No, because in order to modify
Before you
the
said
under-
it was a
I'm sorry.
courtesy or an accommodation. Isn't an accommodation just a sweeter word for a modification?
No, because a modification has to contain an express and unambiguous intent to modify the contract and its terms, and those provisions are not here.
Those terms in that email were in the original contract? It's
No,
sort of
these
like a
specific
yes or no, I'm
terms.
going to let you argue whatever you want to argue, but I want you to answer me. Were those terms in the original contract?
These specific terms,
Yeah.
no.
So these are different terms from the original contract that your client agreed to, correct?
I wouldn't say that it's not, okay, it's, my client.
It
did
says,
say
I
that
have
this is something
received
that-
approval from global management as follows. And then it lists the various things that can now be done. I'm not understanding.
But that doesn't make it a modification.
What does it make it?
That makes it but a sweeter term, an accommodation or courtesy, it's
An accommodation, a courtesy, an allowance for what?
to, at that moment in time, not fully exercise their discretion at that moment to close the counts completely. And as long as,
And it
Things
says
remain
that
the
where?
same.
Where does it say that? Because I don't see that.
it doesn't, I think that's sort of the point. is that
Counsel,
the-
isn't the result in the last bullet point where it says the puts have to be put back in position. Once the puts have closed, Macquarie can reduce the margin. And then it says, the remaining call positions can be held until expiry in December. Isn't that a negotiation? Isn't there an offer? Isn't there an acceptance? Isn't there ratification? Just in this little modification over here.
We would disagree, because this is a directive from Macquarie. They're not asking
So
Adam
with
if they will
respect to the
agree this.
remaining, with respect to the language, the remaining call positions can be held until expiry in December. Who is that being directed to? Isn't it to Macquarie itself?
Macquarie is saying to Caman that the position that can be held, but it doesn't mean under any circumstances, no matter what happens in the market, if Caman goes bankrupt, we still have to hold these positions.
Well, it's
That
the
would be
next
irrational.
paragraph does say that if there is, assuming that the market remains relatively static, the reduction in the margin multiplier will result in an excess in Caman's account, which will be available to call back. So isn't that a further promise? And with the understanding that if the market is not static, that might change?
Well, it is our position that caveat
Yes, thank
there.
you. We understand your position.
Thank you.
Your Honors, I'm happy to answer any questions, but otherwise we would stand on our briefs and on the argument so far.
Well, my question is, assuming this is not a modification and that it is a new contract, what's the consideration?
Consideration, Your Honor, was that Caman closed its puts at a time when, contrary to what Macquarie says today, it was not able to simply, cleanly, and without question close those puts itself. And in fact, what generated this whole discussion and this subsequent agreement was an increase in margin, not a request to close the puts. So in the end, rather than just the increased margin, what Macquarie got out of the deal was the puts were closed, which is more than what they were intended.
No. Are you saying that the consideration is that they didn't, because they got to exercise they have the discretion to close the puts at any time anyway, as long as they exercise their reasonable discretion. So the question I have for you is, if you have a breach, it's got to only be on that point, that they didn't reasonably exercise their discretion. They had the right to do it otherwise.
I hear, Your Honor. I think
No, tell me how it isn't that.
the way it isn't that is that they have a right to do it when in their reasonable discretion it's necessary. So if they,
So we are in agreement that the only way it could be a breach is It's not because you added consideration, it's because they didn't do it in their reasonable discretion.
I would just add, Your Honor, that this whole discussion, as I opened, began in the context of, can we salvage this relationship? Meaning that with the increased margin call that Macquarie asked for, Catamon's initial reaction was, we may need to take our business elsewhere. And this agreement, this modification, kept Catamon with Macquarie. And that, as we've put it on the point on the papers, is itself sufficient consideration.
Thank you.
Thank you, Your Honor.
Smartmatic versus Fox Corporation.
May it please the court, I'm Michael Vadas from Benish Law, representing Smartmatic. This case involves whether the spousal privilege prohibits Smartmatic from retaining text messages between Fox host Jesse Waters and his wife concerning a directive from Rupert Murdoch to stop hammering election fraud and casting doubt on the integrity of the
So
election.
this is an email between Mr. Waters and Mrs. Waters. Why then, and they're married at the time, okay?
Yes.
Why then would the spousal privilege not, why then is there not a spousal privilege and therefore the text messages not be protected as per the spousal privilege?
For three independent reasons, Your Honor, and you can choose any one of them. First, the text messages were not induced by or reliant on the confidence in the marital relation.
How do you know that? It seems to me that when spouses talk to each other about things at work, they may be doing that because they're asking for advice, or it might be something that they wouldn't tell to someone who they're not as close to as their spouse. How can you say with such certainty that this was not induced by the marital relationship?
I make the argument based on precedent, Your Honor. It's a highly fact-dependent analysis that depends on looking at the substance of the communications and also the context. These were messages that relayed a directive that came from Rupert Murdoch and then were passed on by Mr. Waters' producer.
These were messages between Mr. Waters and his wife, wherein there may have been mention of Mr. Murdoch and others. They still are communications between Mr. Waters and his wife.
No doubt, Your Honor, but the substance of the message concerned the directive from Mr. Murdoch, which was...
No, but
So if spouses speak about issues wherein there is a mention of an employer or someone else, then therefore the spousal privilege is not?
No, I'm not espousing any sort of categorical rule whatsoever. It's a very fact-dependent analysis. And the substance here was substance that was shared with other people. Mrs. Waters clearly shared it with her mother.
She shared it with her mother, but at the time Mr. Waters made sent these messages to his wife, he did not know that she was going to share it with her mother. And again, the fact that he didn't know this, he didn't direct it, why does he still not have advantage of the spousal privilege?
He was also sharing the same substance with his producer, with one of his hosts.
We don't have the context for that, whereas we do have the context here of his saying to her, so this is tough. And later she gives him advice and he says, okay, I will thread that needle. And then at the end he says, I'm tired, a little raw, but serene. So obviously the relationship was based on he's getting advice from her in a very personal way, which I suspect was not the case when he talked to his producer about it.
The advice actually came from Mrs. Waters' mother. But the same substance was shared in an extended text message string
But
with
as
his
you
producer.
said, it's not just what was shared, but also the context of it.
Yes.
And this context looks to me like it's shared in the context of seeking advice from somebody you trust.
Yes, Your Honor, you can read that into it, but it's important to note that he shared the same substance, had a very similar dialogue with his producer at work.
Counsel,
In the record.
I'm sorry, counsel. You acknowledge on this record that at least 2 out of the 8 text messages is privilege, correct? There were 8, and there were 6 you said you want to be able to
There were other.
There were
things
others.
involved.
Some number was privileged, some number were not.
Yes.
Arguendo. In any event, the so-called smoking gun of what Mr. Modoc may or may not have told Mr. Waters with respect to the election, you had a full and fair opportunity to depose Mr. Waters on this very subject that you're fighting so hard to free.
Yes.
And Mr. Waters admitted, or at least he stated, exactly what the conversation was with Mr. Murdoch, and it's the same conversation or the same statements that he allegedly made to his wife, that he made to his wife.
Yes, but
So I'm not understanding, then what's the point?
our need for, the level of our need for the evidence is not relevant to whether the privilege applies. This is contemporaneous communication. Mr. Waters' testimony was also somewhat fuzzy. He didn't recall specifics. He
Counsel,
wasn't
you're
sure if
really
it was-
attacking in so many ways just the very essence of a marital relationship. I mean, we always talk about how people need to confide in each other, and what you're basically saying is, perhaps, I want this statement in this context because he would have told the truth to his wife out of all the people in the world that he could have told the truth to. Isn't that what's really going on here? And isn't that a fundamental invasion of the spousal privilege?
I don't believe it is, Your Honor. There are numerous cases from the Court of Appeals and from the First Department finding that the privilege did not apply to much more sensitive communications between spouses. Incriminating statements by a husband accused of murder, statements about money owed to a mother-in-law, statements about coverage of health care for a wife, far more sensitive than here. To find that the privilege doesn't apply here would undo decades of precedent from this court and from the Court of
You mean
Appeals.
to imply that it does apply?
Yes,
here?
yes.
Okay. Thank you. You have time on rebuttal.
Okay.
May it please the court, Harker Rhodes for defendants' respondents. The text messages here between Mr. Waters and his wife are a perfect example of the kind of private marital conversation that is protected by the spousal communications privilege. Faced with a challenging situation at work, Mr. Waters turned to his spouse, telling her about his workplace dilemma and seeking her advice and sympathy. As both J.H. O'Marin and Justice Cohen recognized, that personal conversation between husband and wife is protected by New York law, and Smartmatic is not entitled to demand its production in litigation. I'll start, Your Honors, with Smartmatic's lead argument, which is that this conversation was just a daily and ordinary exchange about ordinary business matters. Respectfully, Your Honor, we submit that that argument borders on absurdity. This is not just how was the weather last weekend or how do you think the Yankees...
Does it matter whether it's a business matter or not? I speak to my spouse about how I feel about my colleagues all the time and how they feel about me all the time. I mean, who cares whether it's regarding work or the household? There's no requirement that it only be about the household, right?
Your Honor, I
It
agree.
be whatever two spouses want to share with each other, correct?
Your Honor, I agree completely.
So let's
with that.
assume that the fact that it's talking about work really is irrelevant.
Right.
What else?
So the issue in terms of spousal privilege is whether or not there is a third person, whether it's related to someone else, and therefore that lacks the confidentiality or the inherent confidentiality.
That's right, Your Honor. And on that point, Smartmatic argues that because Mr. Waters was willing to talk about the same general subject matter with his colleagues at work, that that's sufficient to rebut the presumption of confidentiality. But respectfully, the conversations that Mr. Waters may or may not have had with his colleagues at work just cast no light whatsoever on the substance of the marital communication.
And in fact, it might make it less likely for us to turn over the marital communications when the same information is available from other sources. Why wreck the marital privilege when the party is able to get the information it needs to prosecute its case from other sources, right?
Again, Your Honor, I agree completely. In a situation, we're not claiming that the underlying information here is privileged in any way. It's only the communication between the spouses that's privileged.
So here's a different take on it, is the fact that the wife was walking with her mother while this conversation was taking place dispositive in any way? Was that therefore a communication to a third party? because the mom, the mother-in-law, was present with the wife separately?
No, Your Honor. As both J.H.O. Marin and Justice Cohen found, there's no clear evidence in this record that the mother was somehow part of the conversation or was reading the text messages over Mrs. Waters' shoulder, let alone that Mr. Waters was aware of that. All that the text messages show is that Mrs. Waters didn't respond for a period of time to the text message that Mr. Waters sent, and then she responds and explains that she didn't answer right away because she was walking with her mother. There's nothing to suggest that anything more than at the broadest level, the general subject was shared with her mother. And of course, the presumption here is that a communication with spouses is confidential, and the burden is on Smartmatic under this court's law and under the Court of Appeals law to show that a communication between spouses is not confidential. So there's certainly no clear error in J.H.O. Marin's and Justice Cohen's finding that the content of this communication, the specific conversation that was had between Mr. Waters and his wife, was just for the two of them and not for Mrs. Waters' mother as well. I'd finally just like to emphasize again the fact that we are not saying that Smartmatic can't ask questions about this general area or the subject matter.
Which they did.
And in fact, they did. And the fact that they may not be perfectly satisfied with the answers that they were given in their deposition is
But
not
I thought in Mr. Waters' deposition, he admitted or related the statements to him made by Mr. Murdoch.
That's right, Your Honor. I think he expressed to the best of his recollection what he had been told by Miss Albano, his producer.
Right.
And that communication, again, we didn't object to that conversation at the deposition. All we object to is the disclosure of this particular communication between husband and wife. These words are not words that Smartmatic is entitled to have.
Thank you.
Thank you.
Your Honors, I'd like to address two other issues that I didn't address in my opening. Regardless of whether the marital privilege would normally apply, here, Mr. Waters had no reasonable expectation of privacy in his messages because
Why not?
they were sent on a company device.
Right, and
Fox
so
had-
are there any cases that say that that the marital privilege or that confidential text messages are only if you use your personal phone and not if you use a work phone?
Your Honor, Peer and Boom, this court's decision in Peer and Boom is indistinguishable. It is exactly on point. The court there found that there was no reasonable expectation of privacy in messages sent on a company device, and therefore, and the company had an announced policy, an employee handbook that said you have no expectation of privacy even
No,
in
but in
personal
this
messages.
case,
Exactly.
didn't their policy, didn't the Fox policy say, sure, you can use your phone for, so, and that only deals with Fox. It has nothing to do with you. As to Fox, you have no expectation of privacy, right? As you don't get the benefit of that. And in fact, Fox says you can use if you don't abuse it, okay, if you use your work phone to text, right?
Yes, it did say.
And whether or not, so yes is the answer to that. And you don't have you're not Fox, so that you have no expectation of privacy is between Fox and its employees, not someone who's suing in a third-party capacity.
Respectfully, Honor, I disagree. That's not the way the expectation of privacy works. If any third party, and Fox itself is a third party, is allowed to access the communications, then you have no reasonable expectation of privacy.
But Fox isn't a third party.
That's a stretch, counsel.
That's what the law says, Your Honor. And furthermore, the Fox policy says that Fox may disclose the information to a third party. And that's exactly how we got the information. Fox told Jesse Waters, you need to give us your phone for discovery, and then and that was pursuant to the policy.
If I use my personal phone and I send out a confidential text message, Verizon therefore cannot relay that information to others?
No, Your Honor, this was not a personal phone. It was a Fox phone.
If I use my work phone and I send out a personal email or a text message, again, Verizon cannot now relay that information?
No, Your Honor, I don't mean to interrupt, but Verizon is not your employer. If the court had a policy saying that all court personnel, including the justices, have no expectation of privacy in...
But that's not what Fox says, right? Fox says that you're permitted to use your work phone for personal reasons, so long as it does not consume more than an insignificant amount of company resources and the employee's time, et cetera. It does not say that you cannot use it for personal reasons.
Yes, it allows incidental personal use, but it also says that that incidental personal use is subject to monitoring and can be disclosed to third parties beyond Fox, which is exactly what happened here. So there is no expectation of privacy, even in the personal use
But
that's
Fox
permitted under
made
the
a
policy.
mistake. Didn't it try to get the information? Isn't this what this is all about? Fox says, oops, that's not what we intended to do, and can we please have the text back because this is protected?
Yes, they would certainly like to have it back because they know this would be very effective evidence for Smartmatic.
No, but as my colleague just stated, Fox said, we made a mistake. This is confidential. And although it was on a work phone, it should not have been turned over because it's confidential.
Well, but that leads me to my other point. There is not a case that Fox cites or that I'm aware of where a corporation was successfully allowed to assert the spousal privilege. The communication between the spouses has already been turned over to
No, the corporation is asserting that they should not have turned it over to you because it was privileged, and they made an error in doing so, and they asked you to return it, and you refused to do so.
Yes, Your Honor, but what I'm saying is that they don't have the right to assert the privilege of a spouse. They are not the spouse. They're in possession of
They are
spousal
asserting that they should not have turned it over because it is privileged.
Yes, but they're doing it on the basis of the spousal privilege. They're not the spouse. The spouse's communications have already been given to Fox.
So is your argument now that Fox cannot assert a privilege?
That's my fourth argument. Really, we have all three arguments, but to go back, all four, but to go back to the other one, the no reasonable expectation of privacy, I really urge Your Honors to read Peerenboom because it is not distinguishable. The only difference is that in Peerenboom, it allowed the employee to receive communications, whereas here, the employee could send or receive incidental personal communications. But the dispositive factor to this court in Peerenboom was that the company had an explicit policy saying that any use of company resources, of company devices, or the internet, the communication system is subject to monitoring, and you have no expectation of privacy. It's identical for all practical purposes to the policy here. And the court therefore held in Peerenboom that the spousal privilege did not apply in light of that policy. And there are numerous cases across jurisdictions and by other courts in New York, federal court.
So, counsel, I don't see an argument that, to some extent, Fox didn't have or does not have standing to contest the confidentiality of the text messages.
That's why I haven't featured it, Your Honor.
But I don't even see that in your paper. I didn't see that in your papers. Did you argue that in your briefs?
It's I think, a variant of what we've argued in our briefs.
No, I don't think it's a variant, because I think what your argument that I saw in your briefs it was that that the exchanges between Mr. Waters and his wife were not protected by the spousal privilege. Not that only he, Mr. Waters, could assert the spousal privilege, and that Fox could not assert such a privilege.
You're right, Your Honor. We had three main arguments. One, that the communication was not induced by the marital relation. Second, that it did not involve confidential substance because the same substance was shared with numerous other parties.
So this is a new argument that Fox cannot assert privilege as to these text messages.
Yes, Your Honor.
Okay, so since it's a new argument, therefore it's not an argument that we would consider.
So I would like to just draw your attention back to the third argument based on your
we have your arguments. Thank you. Thank you both.
Thank you, Your Honor.
Thank you. MREF Right Lender 2 versus FPG Maiden Holdings. You may proceed.
Good afternoon. If it pleases the court, my name is Stephen Mandelsberg. I'm with Thompson Coburn, and we represent the defendant appellant, Bank Leumi Israel BM, the National Bank of Israel, which is referred to in the briefs as either Blita or Leumi Israel. This appeal raises two fundamental, important jurisdictional and commercial transaction-related questions.
Counsel, it is undisputed that when Blita bought out an interest to become a senior lender, and that participation agreement is clearly linked to the whole Seaport project. There's no dispute about that, correct?
Justice Schulman, there would be a dispute about that because Blita is not a senior. It didn't buy out an interest in the senior loan. It wasn't a syndicated lender. It was a participant in the loan. And by virtue of the participation agreement, it is entitled to get payments from the borrower to the lender pursuant to the separate loan agreements that are entered into between the borrower, which happen to be co-defendants in this lawsuit, and the lender. The lender here is and always has been Bank Leumi USA, now Valley. So there's no dispute that Blita is a loan participant. There's no dispute that Blita is entitled to receive its pro rata share of payments from the borrower.
And pay taxes?
And pay some taxes, but the question...
And it's clearly that participation in that loan with its then subsidiary.
That's
then
correct.
Subsidiary.
But this court has never...
Counsel, just...
Then subsidiary, the entire loan was designed for the developers to develop a New York property. It's all part of it. It's one package, correct? Even if they weren't a signatory to the actual loans themselves.
That's true, but the loan agreements were entered into with different parties at different times.
One second, counsel. Your participation agreement says it is subject to the terms and provisions of this agreement and of the documents, right? So everything that you signed incorporated the terms of the loan agreement and all of the documents.
No, Your Honor. It doesn't incorporate all of the terms. It incorporates the terms of the loan agreement to the extent that it
No, it doesn't say to any extent. It says, I'm looking at it, subject to the terms and provisions of this agreement and of the Seaport Senior documents. That's what it says.
That's correct, but it doesn't incorporate the provisions.
That's literally an incorporation of the documents into
Your Honor,
okay.
that runs
All right,
against
okay.
the
Let's disagree.
concept
Let's
of
agree to
loan-
disagree. I don't want to
So,
go back.
counsel, you really have to allow the justices to complete their questions before you respond, okay?
Understood.
All right. So let's assume that the documents say what they say, and we can disagree about the... So how is it that you're not subject to jurisdiction here?
We're not subject to jurisdiction because the only peg for jurisdiction is the participation agreement. But more than that, the claim of jurisdiction is under the complaint, paragraph 29, record on appeal 49, is alleged to be under the transaction of business 302A1 peg of jurisdiction. The law is clear that in order to establish that peg of jurisdiction, the only one alleged here, you must allege an articulable nexus or substantial relationship between the claim alleged and the conduct. So the conduct here, as Your Honors have just said, is the entry into the participation agreement. The claim alleged here is by an amity lender plaintiff involving a different loan to a different property to a different borrower that has nothing to do with Blita. So the reason why the lower court erred is because it didn't conduct any evaluation or analysis of the nexus requirement. And that is an indispensable requirement for transaction of business jurisdiction.
But counsel,
Just as
isn't the purpose of the Amity loan in part to fund the second restructuring of the One Seaport debt? And if that occurred, it would also reduce BLETA's exposure. So it seems to me that that creates the, even though it's not the same transaction, the transactions are interrelated in terms of their effect,
I
right?
don't believe the record shows that, Your Honor, because the loan that Amity lender made was to a different borrower to allow it to repay or to refinance or allow it to make a contribution that was a different loan.
No, but that's the allegation. I mean, we're on a pre-answer motion to dismiss. The allegation in the complaint is that that was the effect of the restructuring. The mezz loan restructured to help you reduce your exposure. You may find out in discovery that's not true, but for purposes of personal jurisdiction under 302A1, that's what we have to assume. You can fight that later and say that wasn't the purpose, but that's the allegation in the complaint.
Not quite, Your Honor. The allegation in the complaint is lumped against all of the Seaport lenders. And it's true that they've defined the Seaport lenders to include BLETA, but actually the loan that they're talking about to refinance was for the purpose of doing something for the lender.
That's not what they allege. They allege something else. You might fight in summary judgment, that might be true. But on a pre-answer motion on 3211A8, we have to assume what the allegations of the complaint.
That's not the allegation.
Okay.
And I asked the court to look at the record on appeal and the complaint, and specifically the 10th cause of action, which is the only cause of action, and it's for unjust enrichment, and it doesn't allege anything specific to BLETA.
You have time on rebuttal, counsel. Thank you.
Thank you, Promise.
Good afternoon, Your Honors. Rebecca Martin on behalf of the Amity lender here. Jumping right into what you guys seem to be very concerned about most recently, which is the this articulable nexus or substantial relationship. As alleged in the complaint, paragraph 146, which is on pages 76 and 77 of the record, Amity lender was duped by Leumi Israel's New York subsidiary into extending $40 million in connection with this second restructuring. As alleged in the complaint, $17 million of that was specifically earmarked as an additional equity infusion into the One Seaport project.
So essentially, you are saying that despite counsel's argument to the contrary, you did argue that the effect of the restructuring and the mezz loan was to reduce BLETA's exposure.
Absolutely. And even more specifically, the $17 million was to be used to fund construction costs and interest and fees. Under the participation agreement, Leumi Israel is obligated to fund monthly draw requests for construction costs. So to the extent that Amity lenders' money is being used to fund construction costs, that relieves Leumi Israel of its obligations to fund those amounts. Looking at interest and fees, Leumi Israel, under the participation agreement, section 3 or paragraph 3, is entitled to receive its pro rata share of interest from the New York borrower into its New York bank account through its New York subsidiary under the participation agreement. So again, it's this transaction which we all agree happened in New York with the New York subsidiary, the New York borrower, the New York development. It's directly as a result of that participation agreement that Leumi Israel is benefiting from the $17 million that Amity lender funded. And I'm happy to go back to the first prong, the purposeful transaction, but it sounds like the court has that. Are there any questions on agency or the due process? Otherwise, I'm happy to take my time and sit down.
Thank you.
Thank you.
A few points. First of all, paragraph 149 that counsel just cites, if you look at it, it doesn't refer to Leumi Israel at all. It refers to only Leumi USA, which is the lender, which supports the statement I just made that this is about the lender. Number two, I think counsel is forgetting that there have been two appellate decisions rendered by this court.
But wasn't that with the
related
borrower litigation?
That's correct.
Totally discrete litigation.
Yes and no. Yes and no. The reason why I say yes and no, Justice Schulman, is one, the allegations in this complaint refer to representations about extending the deadlines. And your honors may remember that when we were here back in 2022 and the court issued its December 2022 opinion reversing the lower court's decision that refused to dismiss the fraud-based claims, this court held that those allegations, those claims about oral representations were unenforceable and barred. The second decision that this court issued very recently, in April 2, 2024, dealt in the borrower action, not so different, Justice Schulman, because it involved Blita, the same party. And in the April 2, 2024 decision, this court dismissed all of the claims against Blita. Yes, it's true, you did not reach the jurisdictional question because you didn't have to, because in that decision, you held that the participation...
So then what possible relevance would that have to be as to whether or not there's personal jurisdiction under 302A1?
Relevance is this. The issue raised in that appeal and what this court held was that the loan participation agreement was separate and distinct. The plaintiffs had no privity, contractual or otherwise, not a third-party beneficiary of the loan participation agreement.
Did you move on against this cause of action on the basis of failure to state a claim?
Yes.
And it was, so what happened with respect to, no, the cause of the unjust enrichment cause of action that we're talking about right now? The only thing we're dealing with is A8, correct?
The only thing we're
dealing with is 3211A8. We're not looking at the substance of the claim for whether it states a cause of action. Am I right about that?
That is correct. Okay. But the linchpin for the allegations in the complaint, paragraph 149 says so. Leumi USA had proposed May 31 as the new deadline for obtaining the TCO. These are allegations about an oral extension of the deadlines. And finally, Your Honor.
No, that was it. Thank you very much.
Thank you very much, Your Honor.
Sternkoff versus 395 Hudson, New York. I think plaintiff respondent goes first, Mr. Fitzgerald. You want to go first, or do you want Mr. Fitzgerald to go first? He's the only one with him. Okay. You may proceed.
If it pleases the court, Eric Harris, Colin Dykeman. We represent third-party defendant, appellant James E. Fitzgerald. Very briefly about the facts, this case involves a plaintiff that was injured. He's a steam fitter.
We are well aware of the facts.
Okay. So on appeal,
Didn't Fitzgerald have a contractual obligation to resolve the cleanliness of the facility?
we did not. There was just simply a very blank estimate that was signed. I know normally in the case of a general contractor, construction manager, yes, there is a comprehensive, sort of construction management agreement that delineates all of those responsibilities. But in this case, there is simply a purchase order that was signed between Fitzgerald and the client, MS Communications Corporation.
So you're denying that Fitzgerald provided laborers to clean the site and to remove scraps, garbage, and debris?
Not at all, Your Honor. We did. But I'm saying that That's not in the contract. Fitzgerald did that because they are a construction manager, general contractor, and that's typically what kind of services they provide.
So the fact that you undertook these services, would that not lead to some liability on your behalf, if on your part, if in fact that caused the injury?
I'm sorry, can you?
The fact that you undertook this obligation, although you're stating you were not contractually bound to do so, would that not perhaps lead to negligence, finding of negligence on your part, if that was the result of the injury sustained by the plaintiff?
I do not believe so, and here's why. Well, first off, Your Honor, I don't believe that there is an active Labor Law 200 claim against my clients. That was dismissed against the direct defendant, and I'm a third-party defendant. So any liability I have is derivative of that of the direct defendants. And since the underlying decision that forms the basis of my appeal dismissed that claim against the owner and the tenant, that claim, and since it hasn't been appealed by the plaintiff or anyone else, for that matter, my client should not be found liable based on the notice obligations. The only active claim at this point is 241-6, predicated on 23-1.7 E2. And that seeks to hold my client liable just purely because they are a construction manager, general contractor, and not due to the failure to remove something.
So you would not be, so your argument is that you would not be liable for any indemnification to Ari?
Well, I'm going the other way. I'm seeking indemnification from them because it's my argument that my client is not negligent, and moreover, we have an arises out of language in our contract with.
So you're saying that Ari must indemnify you?
Indeed, and also Par Plumbing, who is the employer.
So the industrial code at 23-1.7 E2 says that floors where persons work or pass shall be kept free from an accumulation of dirt and debris. You took on that responsibility, and you're saying you don't have liability and others are liable to you.
Yes, Your Honor, and respectfully, if you read the rest of the statute, it says as consistent with the work being done, or something to that effect. And so,
well, the remnants of carpet being laid, having no purpose but to clutter a work area, is debris. And Bazdarek, the Court of Appeals, sort of made that clear. I would say in an a fortiori basis. For Bazdarek, there was sheeting that was actually argued by this court to be integral to the work, and yet the Court of Appeals reversed this court and said that sheeting, plastic sheeting, being used to protect the escalator while they were painting constitutes a debris under this very regulation, whereas here, once carpet is laid and there's remnants all over the workplace, and the plaintiff here tripped over it, how could you possibly argue that's integral to the work?
I argue it because the plaintiff's characterization of the carpet as debris and scrap should not be binding on this court. There is testimony from the actual contractor involved, ARI, whose vice president said that there are occasions when you cut carpet where pieces can fit elsewhere. So it's not necessarily, one trade should not be able to say, in this case, a steam fitter, should not be able to look over at a job site and say when a carpet installation's materials constitute dirt, debris, or anything else.
That's really interesting, counsel. It actually has a lot to do with the manner in which the carpet scraps are laid about, right? So if you have a little corner and they're all stacked up in one corner, that's vastly different from having the scraps strewn about. The plaintiff here says, I fell on one of those.
That's also sort of like a labor law 200 argument, because you're talking about means and methods.
No, we're talking about debris, and again, you undertook the duty, not the duty, but you undertook the responsibility of clearing the area of debris. And so what I'm not understanding, why would this not be an issue of fact therefore?
Because
As to whether it constituted debris, whether it was piled neatly in the corner, whether it was spread about exactly, why is that not an issue of fact?
because
You can think about that on rebuttal. Thank you. Just let us know who you are, please.
Thank you, Your Honor. My name is Cy Aidner for plaintiff respondent. Fitzgerald's own incident report and the testimony of Mr. Fitzgerald, its principal, indicates that this carpet scraps were intended for garbage. That's not something that we came up. That's directly in the record multiple times. So it is undisputed based on Fitzgerald's own position that they've taken. Those scraps are carpeted, not repurposed. More importantly, under Bazdrack, I think the status of the underlying object is no longer relevant. Remember, the Court of Appeals undertook the decision where there was plastic on the floor, which was readily acknowledged in that decision as having some purpose in preventing it, but it was improper in terms of the needs for that particular site, given that it was on an elevator. So respectfully, I would say the change in our brief, which was filed before Bazdrack, is that the status of the carpet scraps, even if they were intended to be repurposed, is now irrelevant. The key is, under integral defense, is there an avoidable danger? And the answer to that question is yes, because they could have placed it in any number of ways to get it out of the way, in a bag, in a container, or left it in a room. And then secondarily, is this underlying task otherwise inherently dangerous, which is not. I don't think there's any issue of fact that this is not a case appropriate for the integral defense. And to the extent that the court has no further questions, may plaintiff respondent rest on his brief?
Please.
Thank you so much.
Thank you.
Arthur Turgeson for Par Plumbing, respondent. Good afternoon, and may it please the court. I represent Par Plumbing in this matter. Par Plumbing is only in this case because JEF brought a contractual indemnification claim on the basis that Par Plumbing was the plaintiff's employer.
So can I ask you, was that motion part of the first motion sequence, the motion against you for indemnification, or the second?
There was a motion against us. So there was motions for summary judgment, and then there was motions to renew those. So I think that the first appeal was the first appeal is of the court's reversal of summary judgment against, the first appeal is the court's reversal of its denial of summary judgment that we made. And then the second appeal is
Ari?
No, the second appeal was JEF saying that not only should the case against Par not be dismissed, but that JEF should actually get contractual indemnity.
Against Par?
Against Par.
Okay. So then the only motion that dealt with you was the first one.
No, I'm sorry, Your Honor. I did a poor job explaining this one. One motion was...
I'm sorry, you're right. You're Par. So the only motion that dealt with you is the second one.
So Par moved for summary judgment and was on re-argument was granted summary judgment. That was the first motion. The second motion was JEF saying we should be entitled to contractual indemnity. So one motion dismissed the claim outright against Par. One motion denied JEF's motion for contractual indemnity against Par.
Did the second, let me ask you this, did the May 25th, 2023 order, was that addressed to you or Par?
I am Par, Your Honor, I'm sorry.
I'm sorry, to you or Ari?
I believe that was to Par. I'm not sure if both are actually the same day, but I think that was the one that was to Par, I'm sorry.
To Par, okay, the May 25th was to Par.
I believe.
Okay. Oh, there are two that are May 25. Okay.
Yeah.
Okay, never mind.
So the issue as to Par was whether or not you were required to indemnify Fitzgerald for the work, right?
Yes, and the only basis that Fitzgerald has asserted for that Par has to indemnify it for its work is that because this was a Par employee. And while JEF goes to great lengths to argue that that is enough to find that this arose out of Par's work, this court 5 years ago in DeGidio versus the City of New York held that being the employer and the fact that the employer was J&D and J&E's load was inside of a crane that collapsed, this court found that both of those things together was still not enough to find that this arose out of the employer's work. I'm sorry, Your Honor.
So right here, essentially, your contract was to move certain,
Sprinklers.
Yes, Your Honor.
what do you call it, sprinklers, correct?
Correct, Your Honor.
And the plaintiff here was your employee.
Yes, Your Honor.
And he wasn't even working. He was walking, maybe going to lunch or something like that. Wasn't even the scope of his employment.
I'm sure I'll be hit with this on rebuttal, so I will say this. He
understand
was
what they
carrying, he
said.
was walking something over to a coworker and slipped on carpet that had nothing to do with.
Carpet. So there's nothing to do with steam, with his work here.
Yes, Your Honor. And I'd like to bring up, I'm sorry, did Your Honor? I'd like to bring up a point that was in the reply brief. Counsel tried to distinguish the Gigidio case. I believe his words were, the fact that the injury occurred during an activity, hoisting, was not in the employer's contract. It was vital to your decision that this did not arise out of the plaintiff's work. And then counsel goes on to say, he was hurt because he was quote unquote hoisting material himself, which is not true. He tried to make the plaintiff akin to the crane that broke. In this case, the carpet is what caused this injury. There's absolutely no allegation that he hit himself with the pipe, that the pipe was too heavy, that it was anything else besides the carpet scrap. So while the arising out of language is very broad, this court has found that being the employer is not enough. And Parr's position is that in this case, aside from the fact that Parr signed this guy's paychecks, it had nothing to do with what caused this accident.
Thank you.
Thank you.
Who's next? 395 Hudson, how about you?
Good afternoon, Your Honors. May it please the court. Joshua Ferguson from Tyson and Mendez. I represent 395 Hudson, New York, LLC, MS Communications Corp., and MS Radio, LLC. Your Honors, as set forth in my brief, the Labor Law 241-6 claim against my client rises and falls alongside the claim against Fitzgerald. Same with the indemnification cross-claim against Barfire. I'm just here to request consistency in any decision you render. So I'm not going to belabor the points made by my learned colleague. That said, I am here to answer questions. I would take one exception, Your Honor, to the idea that this did not arise out of Barfire's work. As set forth in the record, the plaintiff was moving sprinkler equipment at the time. Now you might say, well, it wasn't a piece of sprinkler equipment that he tripped and fell on. At the same time, would we say that if it was a piece of oil, if it was water, if it was some other thing, it didn't arise out of the work?
Did he say that? I thought he was walking. He said he was walking. I didn't see that he was moving sprinkler equipment.
So I would respectfully draw your attention, Your Honor, to the record. I believe it's 178 to 179. I'm sure my colleague has a much more accurate citation to it, but it is in the record that he is moving sprinkler equipment to his colleague.
But again, the alleged injury was not caused by the sprinkler equipment or anything to do with the installation of the sprinkler. It was, he testified that his injury was the result of having slipped on a discarded carpet square.
Slipped on a discarded carpet square as he was moving this sprinkler equipment.
Don't we need some correlation between the sprinkler equipment and his tripping over the discarded carpet square?
I don't believe that the contractual language requires that level of specificity. It says arising out of or in connection with the work being done. I do believe, Your Honor, that this is being done in connection with the work.
Thank you.
Thank you, Your Honor.
Yes.
Good afternoon, Mihalina Shooter on behalf of RE Products. I'll just keep my points brief. The primary argument made by RE is that indemnification on behalf of the general contractor is inappropriate, where there is at least some evidence of negligence, which I believe the court has already addressed here. So I can rely on my brief on that unless the court has further questions. The only other point that I would make is that the reply brief by the general contractor, Fitzgerald, tries to distinguish the case law cited by RE, stating that in Other cases, the injury-producing condition had been present for more than 1 day before the accident occurred. I think it's clear that that is not relevant here in the case law that was recently provided to the court. In the Court of Appeals, the Bezdaric decision. In that case, it seems as if the covering of the escalator was imminent. They placed it over and they told them to go work, and then the fall happened immediately thereafter. So I don't think that there is any requirement that the injury-producing condition be present for any lengthy amount of time. So unless there are any questions, I'll rest on my papers.
Thank you.
Thank you.
Blast, Your Honor. May it please the court. Gregory Parada, law offices of Kevin Westerman, on behalf of 4th, 6th, third-party defendant, Finlay Installation Services. As you've heard today so far, no aspect of Fitzgerald's appellant papers or arguments are directed vis-a-vis Finlay. There's no discussion or allegation that Finlay did anything other than install the carpet in a workmanlike manner. If the court is so inclined...
Is there a question as to whether it was your carpet that was laying around?
No, there is no... We were the only carpet installer on this site.
Right.
ARI is a flooring contractor that retained Finlay to install carpet. In the interest, if Your Honors are so inclined, just in the interest of a whole consistency in the decision, Judge Frank, when the parties initially moved for summary judgment, granted Finlay summary judgment dismissing Fitzgerald's causes of action for contractual indemnification and common law indemnification. On re-argument, that second decision dated May 22nd of 2023 reinstated the common law indemnification claim against Finlay. Judge Frank specifically mentioned in his decision that Fitzgerald specifically imposed a duty upon itself to remove the debris, specifically the carpet scraps. Since it's clear that in the decision that Fitzgerald did not delegate the duty to clear the site from debris to any party, including Finlay, there's no predicate to serve for a prima facie cause of action for common law indemnification. And I submit to you respectfully that Judge Frank's, the cause of action for common law indemnification against Finlay should be dismissed. Thank you, Your Honors.
Just want to point out very quickly that to echo 395, counsel for 395 Hudson and Emmis's arguments, this definitely arose from the PAR's work. So the accident happens, there are two individuals who are employed by PAR. The plaintiff was cutting materials and his partner was installing sprinkle heads at various locations throughout the floor. So you have one worker in one location who is preparing the materials, and then he brings them physically to his partner, who then installs them. So I think that the case law for arising out of or consistent with has it so, or makes it so that this accident falls under.
So, counsel, that would mean any time the person was on the premises, it would be arising out of his work, right? Maybe if he was taking a coffee break and walked across and slipped, that you would say that that's arising out of his work?
Well, taking a coffee break, I don't think is like actively achieving your employer's goals at the job site, whereas bringing materials...
Well, maybe going down for lunch after doing, like maybe he drops it off and he comes down to go to lunch. You're saying that's arising out of his work?
I would.
Really?
Yes.
So essentially what you're saying is anytime he steps on that property, it's whatever happens to him is arising out of his work?
As long as he's on that property?
Do you have a case law that supports that?
I believe that there are cases in my brief that support the proposition that workers at a job site who are injured doing things that are really not actively that workers in a job site that are injured doing things that are not within their scope have been found to arise out of have been found to arise out of their employer's work.
Thank you. People v. Anthony Strickland.
Submitted.
Is submitted, thank you. Deceased Rising Up versus New York City Districting Commission.
Good morning, Your Honors. My name is Luke Budiardo.
Oh, unfortunately, it's afternoon.
Oh, apologies. Good afternoon, Your Honors. My name is Luke Budiardo. I'm appearing on behalf of the appellants. We are here today because the New York City Districting Commission made two critical errors during the last round of districting. First, the commission took a distinct, coherent racial group in South Queens that was already struggling to have a voice in city government, and the commission drew lines to make that community's situation.
So, counsel, the question is, why was the drawing of these particular lines irrational, arbitrary, or inconsistent with the charter's mandate?
The drawing of these particular lines was irrational in light of the applicable statutory scheme, which is Section 52 of the New York City Charter. That section lays out...
Could you stand closer to the mic?
Yes. That section lays out 7 criteria that the commission is required to apply when drawing city maps.
But didn't the commissioners certify that they considered those 7 factors?
Absolutely, Your Honor.
But your position is that certain factors should be given greater weight.
Absolutely, Your Honor.
Even though the case law is clear that there's some flexibility in considering all those factors.
I agree that there is some flexibility, but it depends on the kind of flexibility.
Well, is there anything that one factor should be given greater weight than any other factor?
What the charter says in its second sentence is that the criteria must be given priority in the order in which they are listed. That sentence is very clear, and it uses shall language. There is nothing in that sentence that suggests that the commission can balance the factors as it sees fit. It's very clear. It lays out a framework that the commission has to go from top to bottom.
So in trying to adhere to the second criteria that you hold dearly, that there should be ensure fair and effective representation of the racial and language minority groups. That's very important in terms of what you believe the unity map that you offered complies with, correct?
That's correct.
But isn't it clear that based on the commission's map in its totality, they actually created a majority Asian group in Brooklyn? And you're unhappy that you didn't get that same group in South Queens.
That's effectively correct, Your Honor.
But nonetheless, the commission's map created an increase in districts that would adhere to this Charter 52.
Viewed citywide?
Into totality, correct.
That's correct. However, this provision of the charter is necessarily a local inquiry. What it says is that the commission must guarantee fair and effective representation for minority groups. If it's the case that the commission can just say, oh, we created an Asian majority district 10 miles away in Staten Island or in Brooklyn, then this provision is effectively unenforceable because the commission will always be able to say that somewhere else in the city there was some Asian community or some other minority community that benefited.
Well, what the commission is able to say and what the commission is able to actually show are two different things. And here, unlike in some other cases that we have addressed, we have a 71-page document by an expert who analyzed the composition of the various districts and came to and rendered a report and recommendations, which the commission then reviewed and found to be the basis for the redistricting.
I'm glad Your Honor is talking about the report prepared by Lisa Handley. I'm glad you brought that up. What's one thing that's remarkable about not only that Handley report, but every other piece of evidence prepared by Dr. Lisa Handley, is that it addresses the Federal Voting Rights Act. None of those reports say anything about the charter, and that's important because those two sources of law say different things. The Voting Rights Act protects minority communities to the extent that they have an opportunity to elect a candidate. That language was in the Voting Rights Act back in 1989 when this charter was written. The framers of Section 52 of this charter chose a different approach. They chose to ensure fair and effective representation. So at the very least, what that shows us is that the charter imposes a different and I think broader.
But doesn't the report also speak to the demographics of the various districts and the demographics of the areas in question?
Your Honor is correct. It does in general, but the report does not suggest that anyone, not Dr. Lisa Handley, not anyone on the commission, actually thought about the charter's fair and effective representation criterion and how it applied in this part of Queens.
So, counsel, what you're saying is that the ultimate result is not to empower a particular community to select or elect a representative of its choosing, that the fact that this particular community might still be a small percentage of the larger community is not dispositive.
That's absolutely correct. The opportunity to elect standard, which is in the VRA, necessarily implies some kind of threshold that you have to meet in order to have rights under the VRA. But fair and effective has a different meaning. What fair and effective means is having a representative in city government who's going to be responsive to that group's concerns. I see my time is up.
Yes, you do have time on rebuttal.
Good afternoon, Your Honors. May it please the Court, John Shepwong on behalf of the respondent in New York City.
So is fair and
Commission.
effective a consideration, a factor, and was this something that was not taken into consideration?
Your Honor, I think that it's very clear that this was a very important factor for the Commission. I think that redistricting in New York City is incredibly complex. There are countless numbers of different minority communities that need to be accounted for and in drawing those lines. And here, the Commission engaged in unprecedented public outreach specifically to minority communities. And the result of that was 29 minority opportunity districts, which was a majority of the council, and an increase in the number of Asian opportunity districts in the city council map. So I'd submit there's ample support for the conclusion that the Commission rationally applied this very important criterion from the charter in terms of ensuring fair and effective representation. I think that it's important to recognize as well that these criteria are not a district by district analysis. It is a holistic analysis, and I think there's a couple of points in the charter itself that emphasize that. When it's talking about the redistricting plan, the charter states that it's for the election of city council members. And then in the actual criterion for fair and effective representation, the charter mirrors that language by stating that it's such districting plan shall ensure fair and effective representation of these minority groups. It's not an individual district by district analysis.
I wish we could find another word for minority. It's just it's a word I don't like. I don't know what the alternative would be, but I hate that term, minority. You say it's holistic, but we're talking about a particular district and representation within that district. So if we can look to other counties, other boroughs, or other areas, how then do we ensure that there's going to be representation of, let's say, folks of color in a particular area?
Well, I think that representation for purposes of the charter, it's important to recognize that there's nothing about influence in the charter. There's nothing about this theory that the petitioners have put forward now on appeal, which they didn't actually put forward in their petition below. The charter itself is about elections. That's what representation is referring to in the charter itself. So what happened in this case was the commission hired Dr. Hanley to conduct a racial block voting analysis and determined that these are the districts where we can create an opportunity for these racial and language groups to elect their candidate of choice.
So that would be your response to why it was appropriate, I guess, to look at the voting rights for Dr. Henley, to look to some extent to the Voting Rights Act and what occurred then?
Absolutely, Your Honor. The Voting Rights Act is one piece of that the Commission obviously had to comply with, so there was no error in seeking out a Voting Rights Act expert in Dr. Lisa Hanley. But to Your Honor's point earlier, that analysis also included district-by-district analyses of the various racial blocks in the various districts and what their voting patterns were.
So, counsel, understanding that it is far easier to advocate on behalf of a particular neighborhood or community or district as opposed to the entire city or a county, right? Here we have a situation where a particular community says, we are arbitrarily divided by Liberty Avenue. How come we can't be together? Now, counsel concedes that the goal is not to be necessarily a majority within a particular district, but rather to be able to have effective representation and perhaps have a say with others. So here, given the fact that amongst the elements that have to be considered includes keeping intact communities, and that's C, with established ties of common interest, whether historical, racial, economic, ethnic, religious, or other, how does the current districting map comply with this particular priority as opposed to the unity map?
Well, Your Honor, I think you referenced criterion C, which is communities of interest. I don't think that petitioners have actually raised an allegation that this violates criterion C because—
But it goes along with his argument that we're talking about, or they're talking about, fair and effective representation. And in their factual analysis, they are talking about keeping an area, a community together and intact.
I think that, you know, the community in South Ozone Park and Richmond Hill raised—
I'm sorry, speak up.
The community in South Ozone Park and Richmond Hill, which is the one that we're talking about here, they've raised legitimate concerns that the commission considered. And if we're talking about the communities of interest, there are countless communities of interest, and it is especially difficult, I would say, in Queens to divide among various communities in terms of which one should be grouped where. So I think that in that circumstance, we have to look to the steps that the commission actually took here. And I would refer to the certification that the commission outlined in terms of referring to, in terms of explaining all of the community minority outreach that the commission conducted to various racial and language groups, and the importance that it gave to these issues. And I would also point out that it's not just the certification that the commission had. The commission explicitly stated on the record that their concern was that the unity map did not provide sufficient opportunities for Asian voters to elect their candidate of choice. That's what the rationale was.
Asian voters who, what's the rest of what you—
Asian voters to elect their candidate of choice. So that's what the rationale was that the commission stated on the record very explicitly, Your Honor. So I think that when you have I think that the important thing to look at, and I see that my time is up, is it's important to look at the other side of the ledger as well in terms of what the petitioners have put forward in the record in terms of demonstrating a violation here. And I submit that they didn't put forward anything because there's nothing to show that their map was could comply with all of the requirements of the charter in the record before the commission when it was making its determination.
Thank you.
Thank you, Your Honors.
Just one quick point, Your Honors. So my friend on the other side emphasized that the commission has to deal with a lot of stuff when drawing these lines. And I just want to make clear, no one is contending that the commission has an easy job. There are a lot of different communities that you have to make happy. But I think what's relevant here is reading these sections of the charters together. So you have section 51, which lays out a procedure that the commission has to follow. The first step of the procedure is hearing from the public. And
but are you saying that the commission didn't comply with all the procedures?
No, Your Honor.
Okay, so then let me ask you this. At the hearing stage, did the proponents of the unity map submit any proof that their population would maintain population equity, which is one of the things that is required?
Absolutely, they did.
In front of the commission or on the Article 78?
No, before we filed this petition, the Unity Map proposal, which is a matter of public record, includes detailed maps of each proposed district, along with tables showing the proportion of population in that district as compared to others. And all of the proposed districts were below, far below, the 5% population equivalence threshold.
Okay.
On this record, and correct me if I'm wrong, but the very district that you were proposing in your Unity map actually established a Latino plurality and not an Asian plurality based on the actual numbers. That's the record on 382, correct?
That's correct.
So the very map that you were advancing to advance Asian opportunity for fair and effective representation did not bear out the numbers that you're advancing, whereas the commission maps seem to have given greater than Asian opportunity, but actually an Asian majority citywide.
So 2 points in response, if I can just answer, I see my time is up. The first is, as I mentioned before, I don't think that the creation of Asian majority districts 10, 20 miles away really does anything for this particular minority group. And second of all, it's correct that as we drew the map, this district, District 32, would have a large population of Hispanics and a large population of Asians. The reason for that is that the Unity Map it's called the Unity Map for a reason, which is that we created it through a coalition of groups representing a bunch of different groups. We don't see that as a problem, Your Honor, because what effective representation actually means is having a representative in government that is actually going to listen to your concerns. If you have a racial group that's concentrated in a district, as it would have been under the Unity Map, you can be sure that the council member for that district is going to hear that community when it has a concern. If, on the other hand, the community is fractured into different districts, the community effectively becomes irrelevant to the city council. And that's what...
Which is the community of the, that's represented in the coalition, or the community that exists on the ground? Because what you're talking about kind of changes the tenor of what we're saying, we're asking and hearing. You're saying that it's the needs of the coalition as opposed to the numbers, the statistical numbers?
Let me clarify, Your Honor. When I referred to the coalition that put together the Unity Map, I was really trying to explain how the Unity Map came to be. The particular racial group, the community that we're talking about here, is the people who live in Richmond Hill, South Ozone Park, who share common ties of racial ancestry, who all came from India, Pakistan, and Bangladesh. That's the racial group that we're talking about here, and that's the group that does not have effective representation under the maps as drawn by this commission.
Thank you. Thank you both. Rosio Bello versus New York City Health and Hospitals Corporation. As I stated, Justice Gesmer is recused on this matter. Should there be a tie, another justice will be vouched in.
Good afternoon, Your Honors. My name is Irene Ziegler. If it pleases the court, I represent Dr. Vivekant Kalana-Dabata, who from now on I will call Dr. K if the court does not mind in this matter. My position here is very simple. Dr. K saw the patient at Wyckoff Heights Hospital on 2 occasions in his capacity as an emergency room physician on February 23rd and March 26, 2008. The lower court granted summary judgment to a fellow emergency room physician, Dr. Eichenstein, holding, correctly so, that it is not the duty of an emergency room physician to diagnose the patient's condition, but rather to determine if the patient requires admission or can be worked up as an outpatient.
Counsel, if
I'm sorry.
if I understand your arguments correctly, there is a distinction between the responsibilities of an emergency room doctor and an attending physician and a specialist.
Correct.
Who can be called in to consult.
Correct.
And in this case, the role of Dr. K was limited as an ER doctor, or
Yes.
ED doctor, as some hospitals might say.
Yes, and in that role, it was his duty to determine whether or not the patient should be admitted to the hospital or whether the patient could be worked up as an outpatient. On the first admission, or the first ED presentation in February, Dr. K determined that the patient should have been admitted for further workup, and she was, and her care was then taken over by the attendings during the inpatient admission. On the second emergency room presentation in March, Dr. K saw the patient for under an hour, started preliminary workup for the patient's complaints, then signed the patient off to the incoming emergency room physician, who has not been named in this action, who determined that the patient should be admitted for further workup, and she was, and her further workup was undertaken by the attendings during that admission.
So that I'm also clear, your focus here is seeking reversal on the care provided on those 2 days, but you're not seeking reversal, or at least acknowledge the potential of an issue of fact with respect to his care and treatment in April.
Correct, yeah.
It involved some different role, it wasn't an emergency room scenario.
Yes, yes. In his role as an emergency room physician, Dr. K, his duty was to determine, as I said, to decide whether or not the patient required admission for workup or could be worked up as an outpatient. And on both occasions, the first visit in February, he admitted the patient. The second occasion, he went off shift shortly after seeing the patient, and the incoming physician, emergency room physician, admitted the patient. And moreover, during the first emergency room presentation in February, plaintiff's experts have not offered any deviation from accepted standards during that emergency room presentation. The patient presented with symptoms classic of asthma, which she had a very long history of, and rightfully so, Dr. K admitted her for further workup by other physicians.
Was an argument raised for the first time on appeal that Dr. K's expert, who I think was an otolaryngologist, not an emergency room expert, am I correct?
Yes.
They kind of tried to argue that he didn't have the expertise as an emergency room specialist to give an opinion, but that really was raised for the first time on appeal.
Correct, yes, and they did try to argue that he did not have the expertise, but as an ENT, the plaintiff is claiming that an ENT should have been called to the emergency room to evaluate the patient. So Dr. Mazurik, in his expert affirmation, is stating, as an ENT, the one that they're saying should have been called to the emergency room, it was not necessary for me to be there as an ENT. It was appropriate for the emergency room physician to admit the patient for further workup. The workup that plaintiff is claiming should have been performed is not performed in an emergency room, but rather performed in an inpatient setting. If there are no further questions?
Thank you.
Good afternoon, Your Honors. Gregory Casino for the third-party defendants, appellant, New York Presbyterian Hospital. The only thing that...
So let me just start with this.
Yes.
Does the plaintiff have any claims against New York?
Plaintiff has absolutely no claims
No
against
claims,
no
right?
claims.
And plaintiff isn't going to be aggrieved by anything that happened below or anything that happened here, correct?
Absolutely.
Okay.
That is correct.
I want to just make sure that's true, because I cannot figure out why the plaintiff submitted any papers on the third-party action.
I can't understand it either, and if you read the plaintiff's deposition testimony at page 1476, she was happy with the treatment provided because Presbyterian, she was a difficult case. She had a lot of cardiac and respiratory issues, difficult that needed to take precedent, which is why it took longer to diagnose this condition, but we ultimately diagnosed it when she was finally stable to get the...
So then let me, what did Lincoln and the other third-party plaintiff
Yes.
submit in opposition to your motion for summary judgment?
Nothing. Well, let me step back, because that's the crux of the argument here.
No, I know, but tell us what, if we exclude plaintiff's papers, what is left?
Well, the HHC is, their claims against us are for contribution. We're a subsequent treater, so in order for them to, they're essentially in the position of a plaintiff. They have to establish both a departure and a proximate cause by us. And when you're talking about a subsequent treater, they would have to establish an exacerbation, meaning that the plaintiff's outcome and treatment options got worse as a result, based on that they were better on the first day that she came and the day that they're claiming that this diagnosis should have been made than they were ultimately when we diagnosed her. The plaintiff's position on the summary judgment motion was that there was no proximate cause because the plaintiff.
You're talking the third-party
I'm sorry,
plaintiff,
sorry.
right?
I'm
Let's
not-
be
I'm not- This is a
clear.
very unique procedural posture to be in, so I'm not used to this.
I
but
agree.
HHC's position on the underlying summary judgment motion was that there was no proximate cause because at the time that the plaintiff first presented to Lincoln, which was 2 months earlier before she first presented to Presbyterian, her cancer was already so advanced at that point that she was going to require a resection. That's what their, I cited the.
So then what was the basis of the opposition? What was the basis of HHC's opposition to your motion for summary judgment?
HHC put in an affirmation from a radiologist on the element of departure, which I'm happy to discuss departure, but I think proximate cause is much stronger argument. I would say that on the element of departure, all that their expert really explained is, that the cancer is opining that the cancer was there when she first presented.
Did the court below deal at all with the HHC's papers in opposition to your motion for summary judgment?
No. The court below looked at the plaintiffs.
Only the plaintiffs. Okay.
Exactly. Kind of combined the two of us and then said, plaintiff's expert's opinion.
Let me ask you a separate question. Was there a separate there was a separate lawsuit brought between the two of you, correct?
The plaintiff brought the original action back in 2010.
Plaintiff meaning?
Plaintiff, Mrs. Bello, the patient, yes.
Right. Then what happened procedurally?
I'm sorry?
Procedurally, what happened?
Procedurally, what happened about 6 months before the note of issue was filed in the plaintiff's case against HHC, Dr. K, all the other 75 parties in this case. HHC brought a third-party action for contribution against New York Presbyterian Hospital.
And there was no effort by the plaintiff or anyone else to bring any cross-claims or counterclaims or anything else against NYP?
That is absolutely correct.
So what happened to that action? Did she withdraw the action as to NYP?
Plaintiff never commenced an act. The plaintiff never sought to amend her complaint or anything like that.
So I'm confused.
I thought you said that plaintiff brought an action against NYP. And then prior to the note of issue.
No, the plaintiff brought an action against everybody here but NYP. NYP is not a party.
No, I understand that. I understand it. So plaintiff never brought an action against NYP.
Not only did plaintiff not bring an action against NYP, but once HHC brought a separate third-party action with a separate 2017 index number as opposed to the 2010.
That's what I wanted to find out. It was a separate index number, correct? And the two actions were just combined for a joint trial, correct? There wasn't a consolidation.
Precisely,
okay.
Yes. So back to your question, if I may, my time is getting short, but just what did HHC put in opposition to our motion? They didn't oppose our motion. Like I said, they put in something on departure, but really the crux of our argument here today is proximate cause. And HHC took the position both through their expert, and I could quote from it, but my time is short, but from both their expert and HHC's counsel on the underlying motion, HHC took the position that the plaintiff's cancer was already stage 4, and therefore she was going to require the surgery to remove her larynx when she first presented to HHC 2 months prior to the time that she presented to New York Presbyterian.
Counsel, correct me if I'm mistaken, please. So with respect to the July 24th visit at New York Presbyterian where the bronchoscopy was done and where granuloma was found on the left false vocal cord, is that not the pivotal event in all of this, that the granuloma wasn't found, there wasn't follow-up? I see here July 25th that there was a doctor who said, a consult note, that the exam that was being conducted was not appropriate with respect to the lesions that she had. Are those two events the pivotal events in all of her suit?
Well, she didn't sue New York Presbyterian
Hospital. She didn't sue
Hospital.
you guys.
Did she make any allegations about that visit in her complaint?
No.
Is there anything about that in her allegations against HHC?
Against HHC?
Yeah.
Well, she wouldn't because it's
Right.
HHC. She couldn't make an allegation that NYP did something.
So is HHC, did they make any allegations about that incident, that visit?
Their expert may have on the issue of departure, but again, this comes back to proximate cause,
Right.
which HHC agrees with us that there was no proximate cause. We submitted let me just take this, in support of our summary judgment motion. I'm sorry, what I was interrupting?
Essentially, your experts,
Yes.
Dr. Jacobson and Dr. Haddad,
Yes.
pretty much made it clear that whatever was going on in July, it was stage 4.
Yes.
And the claim that we could preserve the larynx is speculation.
And it's more than the fact that it was just stage 4. The patient unfortunately had numerous cardiac
Other
and respiratory
comorbidities, cardiac,
that she never would have been, even if it was just somebody, an otherwise healthy person who had that, it would have been bad enough when she first presented the staging of it. But when you consider all of the comorbidities she had, unfortunately, she never would have been a candidate for larynx preservation.
So that as I understand the record right now, HHC pretty much attempted to adopt your position here.
Exactly.
Did nothing more affirmatively to lasso you in.
Exactly.
Okay. So and right now, the sole issue on appeal is whether you should be in or out.
Exactly.
But
There's no HHC that's here now seeking to get out.
HHC filed a summary judgment motion.
They didn't-
I'm sorry,
they-
they filed the summary judgment motion that they didn't perfect their appeal.
There's no appeal here.
That is correct.
Right, I was going to say, they didn't file a brief here.
HHC is solely a respondent as to our appeal. Their motion for summary judgment was denied, as was ours, and then they filed a notice of appeal, but they subsequently withdrew their notice of appeal.
Right. So they're still on the hook so that Ms. Bello can go after them. Correct?
After
Whatever.
today, there's nothing will happen today that will prevent Mrs. Bello from going after HHC. That is correct.
Thank you.
Okay, thank you.
Good afternoon, Your Honors, and may it please the Court. I'm Alan Rosio, I represent the New York City Health and Hospitals.
So we got to first ask you, you didn't put in any papers. Why are you here?
Well, Your Honor, I think...
Are you aggrieved? Did you put in anything that would show that you were, yes, you were aggrieved by the denial of your summary judgment motion, correct?
Well, right, Your Honor.
Did you put in an appeal brief on that?
No, Your Honor, because...
Well, then why are you here?
We put in a
don't
respondent's
understand why
brief.
you're here.
We put in a respondent's brief, Your Honor, so we're responding to New York Presbyterian's appeal.
You're not, wait.
No, I don't have anything from you.
You
We don't
put
have any
nothing.
briefs from you
We have no briefs from you whatsoever.
on this appeal, nothing.
Yes, you do. Yeah.
No, I don't.
Nope.
I don't...
Check the record. We don't have any briefs on appeal for you.
There's a brief for a city respondent, Your Honors.
I'm sorry?
There's a brief for the city respondents. City respondent. It's a respondent's brief. I don't have the docket number before me, Your Honors, but thank you, Kirk. So docket number 41, Your Honors. I have it from my opposing counsel here. I happen to have printed one out that was my own copy, not from NYC. So, Your Honors, the question of whether or not the plaintiff should have been permitted to submit briefs here hinges on, in our view, on the Mendez case that this court decided.
No, because Mendez has to do with a labor law case where the party doesn't have the opportunity to bring a case. Would the plaintiff, if you win summary and summary judgment is denied against NYP, does that affect the plaintiff's case at all?
No, it does not affect the plaintiff's case. That's correct.
The plaintiff has no stake in your third-party claim. In your third-party action, the plaintiff's not a party, correct?
Yes, that's right.
Plaintiff's not named.
Yes, that's right.
Two separate actions were brought, and they were consolidated for a joint trial, correct? So under
Yes, that's
what
right, Your Honor.
authority would as someone who is not a party to a lawsuit be able to put in papers on an issue that has nothing to do with the plaintiff's claims?
Well, Your Honor, I would just say back to Mendez. Mendez did not
I'm not
face...
talking about Mendez. I'm asking you, what do plaintiff's claims have to do with NYP?
Plaintiff's claims not having to do with NYP.
Nothing.
But it's our view that...
Why would the plaintiff put in any papers? on the claims against NYP. The plaintiff has no stake whatsoever in that in your lawsuit, right?
Well, Your Honor, it's our position that the consolidation here is sufficient to make it a party for purposes of 3212.
Okay, let's assume, I don't know where you would come up with that because it's a joint trial. It's not, if it was consolidation, there would be everybody would be in one caption, right? That's consolidation. This is putting them together for a joint trial, which under the CPLR is a completely different thing. So, when you say the actions were consolidated, they were not consolidated. They were put together for a joint trial under the CPLR. Again, I'm going to ask you, does the plaintiff have any stake whatsoever in what happened between your claim against NYP?
I mean, if the question is, does she have any claims against NYP, the answer is no.
And does she have any stake in your claims against I mean, I don't know. Do you have some kind of side agreement we don't know about?
No, Your Honor, of course not. So, I mean, Your Honors, I mean, I think.
Let's talk about your answer. Do you agree with NYP that you agree that there's no proximate cause?
Well, the question here is whether or not there's a tribal issue of fact, Your Honor.
Right.
So, I mean, we took the position in our expert affirmations that there was no proximate cause, but we also accept at this stage, and that's why we didn't perfect our own appeal. We only filed a response brief that that there is a tribal issue of fact.
Well, let's assume we don't agree. Let's assume we don't take plaintiff's papers into consideration because obviously the plaintiff has no stake in what happens between you two. What have you put in to raise an issue of fact?
So we did argue that there was, as my colleague says, that there was a issue after the treatment, Bellows' treatment had ended with us in late November, early December 2008, and that they misinterpreted certain scans that had been done in August and I think November 2008. That's on pages 940.
And you're saying there was proximate cause with respect to that?
At the very least, that could have exacerbated her condition.
Your expert said that?
I'm not sure if our experts said that explicitly, Your Honor, but that's the gist of our argument below.
Okay.
Look, I think that if the court is going to reject Mendez in terms of its application here and decide that the consolidation is an issue, that poses some difficulty to our argument. It's our view that 3212 is broad enough to encompass plaintiff here, and the plaintiff can give the full picture, Your Honors, of the case that we ourselves alone cannot give, because what was happening was she was going back and forth between our hospital and theirs, and without her input and the input of her experts, you don't get the full picture.
Your hospital and between Lincoln and NYP?
During the course of in mid 2008, Your Honor, there were appointments at both locations, and that was so. There's a period where it covers.
And so, counsel, you stated that you put in a reply to, you put in an appellate's brief as to the plaintiff as well as NYP, because we don't have a brief from you. I'm checking now.
We just have a respondent's brief, Your Honor. That's document number 41 on NYCIF.
Okay, because I'm checking now to get a copy of it, because unfortunately I did not see it. So.
No, I mean, I didn't see it either. We looked at our files. We don't have anything from you on it.
Exactly. So that was one of the things, is that there was no brief by you. So I'm checking now to see when it was filed.
This is the stamped, Your Honor, Appellate Division, 1st Department, 32724. This is my brief. So it says docket number 41. So at the very least, I filed a brief here, Your Honors. Whether or not you agree with our position is a separate issue.
No, I know, but that's kind of troubling.
That's not the issue.
Yeah,
it's not whether we agree or not. It's that we didn't see it. It wasn't.
Right.
We weren't privy to it, and so I'm checking.
But it was filed, Your Honor.
To see what happened.
I can't say why you don't have it.
What I think is ironic is that you are a direct defendant. Ms. Bellows sued you directly, Lincoln Hospital and Wyckoff.
Right.
You're part of the same system.
Bellows sued me. Yeah, you
exactly.
sued us, yes.
And now you're seeking to have the plaintiff serve as your ally in your third-party complaint.
All we're saying is
it really makes no sense.
To me, I don't understand.
All we're saying, Your Honor, is that there's a tribal issue of fact as to us, and for much the same reason, there's a tribal issue of fact as to New York Presbyterian. at this stage.
Thank you.
Thank you, Your Honors.
All right, good afternoon, Your Honors. My name is Jason Steinberg with Harris, Kane, and Goldfarb. I represent the plaintiff.
Here's my question. Were you aggrieved by any of the orders below?
No, we were not
Then
aggrieved.
why are you here? Why did you file a brief? Do you agree with me that you must be aggrieved to file an appellate brief, to file anything? And we all agree you're not aggrieved.
Well, first I'm going to start with the CPR that says any party can submit papers.
Are you a party to are you a party to the action between those two?
Not a direct party.
Right. You're
joint
not
file.
any party, not a third party, not a counterclaimant. You're not a party, so that doesn't help you out.
All right. One other thing I would address is, if
I
you
just
allow me
want
to
to
speak,
again ask you, why do you file a brief when you're not aggrieved?
I'm going to just answer that question. With the respondent's brief, when there are certain allegations being made, all right, by New York Presbyterian, you know, as far as the development of the cancer, and they're making certain allegations that could potentially harm the case, we have an obligation to speak up and say that's incorrect. So in that regard, like that's what Mendez says. Mendez says,
No,
if you're
Mendez says in a labor law case where the Graves Amendment, by law, you may not file a direct claim. Let me ask you a different question. Why didn't you file a direct claim against NYP?
I can't answer that question because that happened a long time ago, and it's not on the record as
So
to
if you're not suing NYP directly, why do you have any ability to talk about NYP's care? It matters nothing to your client.
Okay, the answer to that is, as in Mendez, and I understand it's a labor law case, but
Let's not talk about the case. I want to talk about why you have the right to insert your opinion in a lawsuit to which you are not a party and the claims have nothing to do with you, and you have affirmatively chose not to sue.
because there are allegations and assertions made by New York Presbyterian, there are allegations and assertions made as to the development and the stage of the cancer that could potentially harm our case, and we have an obligation.
So then why don't you sue NYP directly?
We can't at this point.
Why not? It's a relation back.
I don't think that would be applicable in this case, but the purpose of the papers is to address the allegation of an injury, just like in Mendez, where they're saying you didn't sustain a grave injury. The plaintiff said that's not accurate, and the court said, well, you can put papers in that regard because you're allowed to address that claim. It affects your lawsuit. That's the only thing I can say to that. You're right. We didn't sue them. I can't.
And this is not a labor law case in which you would be prevented in any way, shape, or form from suing NYP directly, right? That's a unique circumstance. You had all the opportunity in the world to go directly after NYP, in which case you would have all the right in the world to talk about NYP's care, but you didn't, and you are not a party in the lawsuit that does talk about it.
So if I may, so counsel, you're relying on 3212B, right? Which does not say what any party means. Any party, the plaintiff, the third party plaintiff, the fourth
Yes.
party defendant, whatever. Way versus Grantling says that the ability to submit papers includes a party with no interest in the outcome of the third party action. Is that what you're relying on?
Relying on that, and of course, like I said, the strongest argument really is the Mendez case.
But those are both labor law cases, right? Where the plaintiff was prohibited by the Graves Amendment from bringing a direct claim.
I agree. I'm not disagreeing with that, but I don't think the fact that it's a labor law case is really the necessary distinction, because the fact of the matter is the third party defendant, who the plaintiff in that case, labor law or not, the third party defendant asserted a claim that was potentially harmful to the plaintiff.
So how do you distinguish all the myriad of cases that say that if you're not aggrieved, you can't put in a brief on appeal? Or if you're not aggrieved, you have to, or you're not a party, you have to move to intervene.
Well,
how do you distinguish all of those cases, of which there are, frankly...
If Presbyterian was granted summary judgment, I think it might be a different scenario. At that point, well, we're not aggrieved. But we're not at that stage yet. They put in papers because the motion was denied, asserting specific claims potentially harmful to my case.
So
That's
let's.
why, yeah, you addressed it with papers saying that's not.
Ask one quick question, please. Let's do that. Let's say NYP says it's all HHC's fault, right? Or HHP, I'm sorry, the client you've sued, says it's all NYP's fault. And the jury finds that that is correct. It's all NYP's fault, right? How is that going to hurt you? You have no stake in that. The client you've sued has been found not liable, right?
If they're found not liable, then the assertion was they were going to point the finger at Presbyterian. Right. So they get out.
How do you have a stake? How do you have a stake as to whether or not NYP is found liable? You don't. Because either way, the only claim you have is against HHC.
Right. And if HAC, like the base of their claim is contributory negligence, to say, well, we're not fully at fault here. It's really NYP. And I'm saying, whoa, that kind of impacts my defendant here.
It doesn't, because you haven't sued them. You couldn't get CPLR relief. You couldn't get any kind of relief.
It would be between them and NYP.
But he could seek but Lincoln Hospital could seek a diminishment or a reduction of their fault to the plaintiff because they're blaming another party. That's
Well, not to beat a dead horse, but we still can't find your brief. I'm sorry, but we've checked and we still cannot find a brief submitted by you. So we need HHC.
Right.
HHC.
Yes.
That's what I'm saying. We still can't find your brief. So I need the information from when you submitted it, et cetera, because it's not in the system. So.
If there are any other questions, it looks like that was the focal point, but
Thank you.
Thank you.
You did have time on rebuttal. I don't know if you wanted to use it or not. No. NYP.
I will be brief, Your Honors. Just to bring up something that the plaintiff was talking about at the end and why he felt that he had standing to bring put in papers as to NYP was some sort of argument.
Well, apparently you were making certain statements I think the argument was that you made certain statements in your brief which could impact the...
We argued that NYP's care was that the NYP's treatment complied with the standard of care, and that by the time the plaintiff first presented to NYP on July, I think it was 8th or July 12th of 2008, there was nothing more that could have been done for her.
And isn't that what HHC is arguing?
That's what HHC.
So how could your argument hurt plaintiff?
Exactly, and nothing we say, we're not talking about HHC's care. We couldn't make an approximate cause argument only looks prospectively. I mean, maybe you look at some things that happened beforehand to have the expert formulate their opinion on staging and things like that. But there's absolutely nothing that we put in our motion papers or any of our experts said anything about what HHC does. That's just not the way that things are done.
No, but did you put anything in your papers which was derogatory or which was incorrect as to the plaintiff, as to her condition, et cetera?
No, we put in an expert affirmation from an otolaryngologist and a head and neck oncologist who both opined that her condition, that she was treated properly.
And so let me ask you the same question, I think. If the court awarded you judgment on the basis that your care was proper,
yes,
that would not in any way, shape, or form affect the decision, the claims between plaintiff and HHC, correct?
It would not, and I may be getting a little into the weeds here, but it would actually, I believe, would be beneficial to the plaintiff because then...
I think that goes back to Judge Shulman's
and
question
Article
about
6
how could you put in papers?
Right, so if there's a trial now with everybody as a subsequent treater...
We're dealing with discrete timelines. In other words,
Yes.
the services Wyckoff and Lincoln Hospital provided her was, I think, February to July of 2008, and it first started with you in 2008, correct?
Yes.
July going forward, October, November, even there was a little back and forth, but it was really, so whatever your position was in July of 2008, is very different than determining whether that the laryngeal lesion could have been picked up earlier.
Exactly. It has nothing to do with them. And
But they are arguing that there was back and forth.
there was, the plaintiff came to us, the plaintiff went to Lincoln Hospital they had an emergency department visit in November, and then she was subsequently sent over to NYP. There was no back and forth treatment here, and the plaintiff hasn't made any claims regarding that, and that was so close to the time when the cancer was diagnosed. She was diagnosed in the end of December, like about a month later, that nobody's arguing that little bit of a difference, that little, time that she stepped into HHC's hospital had anything to do with the claims here. And I would just to bring up, to follow through on just the thought I had with Your Honor, Article 16, if this goes to trial, and as a subsequent treater, every single person here, and if NYP was still in the case, every person and all the defendants in this very large caption could turn around and say it was them. And the plaintiff would have no remedy because the jury could put everything on us. Everybody's share of fault would be below 50%. Everybody could say I'm only liable for my proportionate share, and would actually hurt the plaintiff. But if this court, which I believe it should, says that NYP was complied with the standard of care, there was no proximate cause, the plaintiff none of the defendants could do that. So it's actually so I don't understand what it is that the plaintiff is seeking here and why the plaintiff is trying to interject into what is just our dispute here.
Thank you.
Professionally, not personally.
HHC, could you please see the clerk and clear this up in terms of what happened to your
And
brief?
for the record, I do have a copy of HHC's brief. It was filed.
Well, we're glad you have a copy.
Yeah.
Thank you. NYU versus the City of New York.
Good afternoon, Your Honor, and may it please the court. Alan Schoenfeld for New York University. With the court's permission, my partner Seth Waxman of the Bar of the District of Columbia, who's been admitted pro hoc, will argue.
Thank you.
Thanks, Your Honor.
Thank you, and may it please the court. The New York Court of Appeals has held repeatedly that the total exclusion of colleges and universities from a residential district, quote, is beyond the scope of locality's zoning authority.
But Mr. Waxman, would you agree that you're not totally, that NYU is not totally excluded because it can apply for a variance?
Absolutely. And
Okay, and so you submitted an affidavit from the NYU employee, Elise Wagner, that's showing that the BSA applies a deferential standard when ruling on a variance involving an educational institution. Would you agree with that?
I agree that they...
Well, that was the language submitted by in your papers.
So I agree that prior to this rezoning, one of the buildings that NYU owned in NoHo, prior to rezoning, it applied for a variance for.
But that wasn't the statement that Ms. Wagner made. She was making a general statement about the BSA's process and specifically stated that it applies a deferential standard when ruling on variances involving educational institutions.
That is correct. And if I just may explain what our difference is here with respect to variances. With respect to general restrictions like maximum height, building density, et cetera, we have no problem with the fact that if we propose to build a building in NoHo that exceeds any of those general restrictions, we have to get a zoning variance, and the city is quite correct that when it adjudicates requests for a variance of a general restriction, it applies a deferential standard.
That's not what Ms. Wagner was talking about in her affidavit. She was talking more generally about the BSA applying a deferential standard consistent with Cornell when it rules on variances of any kind made by educational institutions. Are you disagreeing with what she said?
Well, number one, there has never been a variance granted with respect to an educational institution under this rezoned district. Number two, if I just may finish, the New York Court of Appeals and this court itself has repeatedly stated that the process of obtaining a variance, as opposed to the process of satisfying certain special use permit conditions, of which there are none in NoHo, is materially different. And I can explain
Well,
why
actually,
even applying...
what I'm curious about is that I looked very carefully in your papers to see if there was any analysis of the difference of the burden on NYU in applying for a variance given the deferential standard consistent with Cornell applied by the BSA for educational institutions, whether there was any difference in how educational institutions are treated in that context from the way they're treated for applying for special permits. And I didn't see any analysis of that in your permits that would show why, in fact, it was any more burdensome or difficult to apply for a variance.
It is in fact on pages 20 through 25 of our reply brief.
I'm not talking about in your brief. I'm talking about factual showing of the difference. A non-conclusory factual showing as to how you are burdened by having to apply for a variance given the deferential standard as opposed to applying for a permit.
These are not factual. I would say that the legal standards are different in 5 respects, which I will now explicate. In order to get a variance under the so-called Cornell deferential variance standard, NYU is required to provide to the zoning board's satisfaction a showing that it proves that it must have a programmatic need to the BSA's satisfaction.
So
Cornell
let me stop.
says
Let me
that
counsel.
may not be a condition.
Let me stop you. Does anyone else in the neighborhood who gets this new residential zoning have to do that?
No.
Okay, so that's one thing.
That's one. Number 2, the BSA is required to allow only the minimum amount of variance necessary, absolutely necessary, to satisfy the, quote, programmatic need. Also, absolutely
Where is that
prohibited
requirement? Where is that requirement?
It's, I don't have the zoning.
It's in a public record, right?
But this is not in dispute.
So, counsel, let me back up just a little bit. So, I'm looking at the city's papers, or I think it's the city's papers. Generally, community facility use and use group 3, including colleges and universities, schools, libraries, museums, non-commercial art galleries, and long-term care facilities is permitted as of right in residential districts. So here, colleges and universities, dormitories, fraternity, sorority houses are specifically excluded.
Correct.
You're talking about the permit or variance that you would have to apply for if you were to, if NYU was to expand the use of a particular building. How does that differ, just paraphrasing what my colleague asked, how does that differ now in this multi-use special district, which seeks as its goal to create affordable housing, right? How does your position, NYU's, I don't mean your legal position, but your actual position, what you would have to provide, differ from what a library or a museum or a long-term facility would have to do?
The additional requirements that we have to come in, a library or a museum or another non-excluded use requires a variance only if its plans otherwise somehow violate an existing general zoning restriction. We also have to get a variance to satisfy any of those things. But because the city council included in the creation of this district a statement that educational university uses shall not be permitted, We are going from a process in which, and the New York Court of Appeals has said repeatedly that the variance process is inappropriate, not just for this particular thing, it is inappropriate. The BSA cannot legally cure the
We're just talking about standing today, counsel. We're not talking about we're just talking about why you have standing. So you're going off.
Here's why we have standing. They say we don't have standing because we have to apply for a variance first, and we might get one. There is a century of precedent saying that someone who was challenging the facial constitutionality of a zoning regulation does not need to apply for a variance.
I'm glad you raised the question of constitutionality because in your briefs you cite no section of any constitution. What constitutional section are you relying on?
So there is actually in the complaint, and I can't recite the paragraphs, but the complaint.
But in your briefs you don't address anything about a constitutional
We don't,
section.
because Chief Judge Kaye in Union College said that a prohibition of educational uses in a residential district is unconstitutional. Now, I can explain what the original reading of that was, but there is a prohibition against, it is beyond the authority of local zoning authorities to do anything unless it's specifically allowed to by statute to restrict uses that go beyond the morals, general welfare, and safety. I think there's one other thing too, of a community. Anything beyond that is beyond the constitutional authority of a local zoning district to do. And the Court of Appeals has said repeatedly, it is not, educational uses, university uses are supportive of the public morals, safety, general welfare of a community.
But they can still be regulated, correct?
They can be regulated by means of a special permit process in which, unlike a variance, and I just want to emphasize that there is no special permit process in NoHo. The city council could enact one once this variance condition is struck down. But when you go to a special permit process, number one, the process starts with a presumption that the proposed use, that is university use, is allowed so long as if there are any special permit conditions that are specified in advance, they're met. In the variance situation, it presumes that the proposed use is not allowed.
Except where the variance is adopted by a BSA applying that is deferential to the Cornell standard, correct?
It is demonstrably not doing that, nor could it. It requires that we make a showing to BSA's satisfaction that we absolutely need to use this building for that purpose.
And that language is specific within the amendment, right? It says the following uses in use group 3A shall not be permitted.
Right. I mean,
So essentially what you're saying is you have to prove something that no one else who has that general right of residential use has to prove, and that's your harm.
The reason that and that's the harm. And I would say that.
But counsel, you're claiming that harm comes from ZR 143-11, right?
Yes.
Okay, but before ZR-14311 was adopted, you also had to apply for a variance in order to use any of your buildings in Soho or NoHo for educational purposes, correct?
Right, and the reason...
So I frankly don't understand how your position has changed, because before the zoning regulation was amended, you had to apply for a variance, and now you have to apply for a variance. So it seems to me that your situation is unchanged by the adoption of that regulation.
The situation is very changed because the district has been rezoned to permit and indeed encourage
I understand.
residential.
No, it was rezoned, and that affects other people, but it doesn't affect what you have to do in order to use your buildings, correct?
So if I understand Your Honor as asking perhaps why Justice Leibowitz was incorrect in saying
No, I didn't
you were
ask
prohibited
anything about Judge Leibowitz. I asked you how you are burdened by the adoption of this zoning regulation so that you have to do anything different from what you would have had to do beforehand in order to get permission to use any buildings for educational
Let me
purposes.
answer your question with the assumption that we're not. The relevant standing question is not, are we worse off today than we were yesterday before the ordinance was
Well, I
enacted?
agree. My question would be, are you treated any differently at all? And I don't see any difference. What is the difference in how you are affected by this new regulation?
I must not be, I want to be responsive to Your Honor's question. I must not be, I will assume for argument's sake that we had to apply for a variance before this was enacted. That is, when it was still just an industrial zone. And that in a variance application, we would have to make the kinds of showings that the city says we now have to make. We do not, as a matter of New York law, Chief Judge Kaye said it's constitutional law, we do not have to make those showings with respect to the educational use in a residential district.
This is
And
not
there
a
is
purely
nothing-
residential district. It's a residential/manufacturing district. It's a different kind of district than there has been.
Well, I suppose, you know, if Your Honor is suggesting that you could distinguish Union College and Cornell and Pine Knolls on the grounds that this permits not just single-family homes, which all those districts were, but permits homes, multifamily homes, and industrial and commercial uses, and therefore it is okay to prohibit educational uses, that would be a way to distinguish binding precedent. But one thing is for sure, the board of the BSA cannot legally cure the unconstitutional provisions of a law through the variance process.
So again, counsel, we're dealing with the standing now, so you have time on rebuttal.
Okay, thank you.
Good afternoon, and may it please the court. Claude Platten on behalf of the city.
So, counsel, I'm going to jump right in.
Please.
Looking at a map of the special Soho NoHo mixed-use district, and it's bounded by West Houston Street, Thompson to the west, Canal Street to the south, and Center Street to the east, right? Within that area, NYU has buildings that it either owns or leases. Why does NYU not have standing, understanding that it is not free to use those buildings for educational purposes unless it gets special permission through a variance, unlike anybody else in the new district?
Okay, so the first answer to that is they do not allege, never have claimed, that they intend to put any of those properties to a use that's now prohibited.
I thought that there was something in the record that said that they need to have more classrooms, but they haven't even bothered to do the plans because it's a rejection off the top. The use is barred.
Well, what they've said is that, and they've presented facts that suggest it's plausible that it's someday in the future, they will have need to put classrooms, perhaps dormitories, they even said that, into this district. But what an injury, in fact, has to be an imminent injury, and they have not said that but for this zoning provision.
Well, they own property in the district, right?
They can continue to put it.
They own property in the district, and they're being treated different. They've been carved out from the regular residential rules in that district, correct?
Right.
All that's true. And I haven't found a single case, in fact, I found the exact opposite, that says that today I have to be building or next week I have to be building. None of the cases on land use, particularly zoning cases, say that. Do we agree?
Well, I don't think there's been a case.
Right.
I'm sorry, Your Honor. If I could just finish.
We agree then.
No. My answer is I'm not aware of any case where a party has gone to court to challenge a zoning provision based on the idea that at some time in the future it will be a hindrance to their ability to
So
develop.
what about Cornell? And I'm going to read the part that I said before. The zoning boards involved in Cornell were in fact using an impermissible criterion in that they demanded that the schools make a showing of affirmative need for the proposed expansion. So here you're talking about actual property, either leased or owned that is available for certain uses but cannot be used because there is a bar. How does that not give NYU standing to participate, to challenge this particular zoning?
Right. Well, so the Cornell claim, it's a guarantee of the opportunity to have a case-by-case assessment by the BSA in this instance of a proposal to develop property that would otherwise be prohibited.
I don't think they had a BSA up in Ithaca.
I'm sorry, I didn't.
I don't think they have a BSA up in Ithaca.
No, in this instance, it's the BSA.
Okay.
So, but my point is, in Cornell, there was a concrete proposal that Cornell University and Sarah Lawrence College wanted to do. They were prohibited by the zoning provision. There was no dispute that there was no pathway for them to be able to get a case-by-case balancing assessment the way that Cornell requires. In Union College, the provision was enacted, that restricted educational use was enacted, and then 10 years later, the university had a reason to develop in that historic district, and they then challenged it. And the only provision that the city of Schenectady offered was the traditional variance that's limited, that puts the burden on the applicant to show undue hardship, and there was no dispute that that wouldn't provide.
But let's talk about, wasn't the original amendment going to include colleges and universities, and wasn't it taken out after there were public hearings?
That's the sequence, but the point is,
right, and then
the BSA is. I'm sorry.
Then isn't there a demand, therefore, that there be, for example, a secret analysis every time that a variance be sought, so as to ascertain what its impact would be on the surrounding community? Doesn't that put NYU in a position where it really does have standing?
No, Your Honor. Just to be clear, the question, as we've shown in our brief, the requirements to seek a special permit from the BSA, the requirements to seek a variance from the BSA are almost identical when you're talking about an educational institution. They may require the same sorts of showings, plans, an environmental analysis, the statement of findings, really the same process. And the question is, there's no showing here that the burdens would be different. And the BSA has shown time and again that it understands what Cornell means, that it requires a case-by-case.
So if there's no difference, why carve them out? Why carve it out? Why carve out educational institutions? That doesn't, it seems like that's a facetious thing to say.
Your Honor.
Let me ask you a different question. I'm sorry, I shouldn't even, that just seemed to me like, how do you distinguish our language in matter of real estate board versus City of New York, which says, owners of real property who are subjected to a new zoning classification or other use restriction are presumptively affected by the change and therefore have standing to assert claims? How do you distinguish that?
Okay, well, as to the point about the application of the BSA, which I think is properly understood as a ripeness, the point is that this Cornell claim.
No, I'm just asking you how. I mean, we've said if there's a zoning variance, you own property in the district, and it affects you, you have standing.
Well, to the question about injury in fact, which is what the court was talking about there, the allegation that the court found injury in fact was that there was an immediate diminution in the property values as a result of that conversion moratorium. NYU does not rely on a diminution of value here. It's relying on the fact that it says, need to put classrooms in the zone, and at that point, this will hinder their ability to do that. That is a future-directed injury. It's a someday intention under Association for Better Long Island. That's not an imminent injury in fact. So that's the first piece. So the second is that this claim isn't ripe because fundamentally there is no claim under Cornell until a university has sought to develop and been denied that kind of deferential balancing test.
I just don't understand why there was an amendment then.
Well,
why was there an amendment to create the special district? I mean, I'm scratching my head. I looked. What I saw was affordable housing. And then I see all the uses that are allowed, and I say, wait a minute, this isn't affordable housing. long-term care facilities, is that affordable housing? Libraries and museums and non-commercial art galleries, are those affordable housing? I don't understand it. Why not require everybody to just do a variance?
Well, the record doesn't, if the question is why the educational institutions, colleges, universities were carved out, there's not a lot in the record about that. But for purposes of the justiciability analysis of standing and ripeness, the question is whether it is now clear that NYU will not get the kind of, that under this amendment that carves them out, they won't get the kind of deferential consideration that Cornell entitles them to. And you fundamentally can't answer that question until it's been put to the BSA.
You start with the negative when you go before BSA. I mean, that's the big difference here. The other entities start with a positive, with a permitted use as opposed to a rejected use.
Well, I disagree because the BSA recognizes that it has to adjust the variance standard to comport with Cornell. You can look at the NYU's variance application, which is in the record. You can look at the others that the parties have cited.
So, Counsel, can you explain to us what goals were attempted to be served by what's, I guess we could call the university limitation in the in this zoning regulation?
Well, we don't have a lot of contemporaneous statements about that.
But you must have some understanding of what the reason was for adopting that limitation.
Well, there was community opposition. There was concern voiced in numerous hearings about NYU's sort of just the sort of effect that they have on dormitories and housing.
Right, so the effect that they have on the district. So since, I don't want to say they're being targeted, but since there's that carve out, doesn't that perhaps lead to a determination that they do have standing because there is an injury?
But I think the question is really, the BSA is the body charged by the charter in the first instance with construing this new zoning provision, deciding how it aligns with Cornell. And the question is, until the BSA has spoken, has given us their interpretation, whether that this and educational institutions will still be able to get the kind of deferential review that Cornell requires, NYU doesn't have a right claim.
Well, why would NYU therefore not have a right to have some input in what the ultimate determination is going to be?
Well, they'll go before the BSA. When they have a plan, they don't now have any intention to put classrooms into this zone. When they do—
Why should they be forced to actually coming up with a plan, hiring experts, et cetera, going through a whole plan wherein there's no— we don't know for certain that it will be approved because of this whole carve-out?
Well, two things. Cornell doesn't guarantee a glide path to development for an educational institution. Educational uses can be barred except with a special permit. And as I said, the process is not different. Has not been different between— I'm sorry.
And say to you, except the zoning regulation allows it for everybody else, right? Nobody else but NYU has to jump through any hoops in that area, the new zone, to build whatever they want to build, except the general zoning, correct?
And that's—
NYU
yes, and
is
that's
the
not—
only one who has to jump through the extra hoops, correct?
Well, colleges and universities.
Well, it's the only college.
It's the only one that has owned.
Is there another college or university in that area?
Well, I don't know. There may be others.
I don't think
but
so.
I guess the point is—
my colleague, she told you the map, and I don't know of any colleges or universities bounded by Thompson, East Houston Street, Center, and Canal.
So
my recollection of that area is that it's only NYU.
And they're bringing a Cornell claim. The Cornell claim is that is that they're being denied the opportunity to have a case-by-case deferential assessment of their ability to develop in that zone. Until we know if that's going to happen, it doesn't matter if the provision was written as a flat prohibition or as a prohibition that says only with a special permit. The question is, after they go in front of the BSA and get review, and they can come back before this court at that point, and you'll be able to look at the record and say, did they get the review?
That's the merits. We're talking about standing. You're saying they actually have to go in front of the board where no one else has to go in front of the board
With a plan.
with a plan.
With a specific plan as to specific areas and streets, et cetera.
Just to be clear, there's two standing points, and one is really, and this is, I was saying earlier, it's ripeness. And the point we're making is that this claim isn't ripe until we know what the BSA is going
And
to
is that based on the Court of Appeals decision in Association for a Better Long Island?
I think that case speaks directly to this point, that the challenger there was challenging an environmental permitting scheme that they didn't think was going to favor them. And the Court of Appeals said that claim's not ripe until you apply for the permit and we know whether you get it or not, because until that point, the harm is too speculative.
So in your view, this zoning change doesn't have a deterrent effect?
No, because
And therefore, you know, go ahead, develop a plan, pay all the money, go before the Board of Standards and Appeals, which is a lengthy process, as you know, and then let's see what happens, and then you can sue 2, 3, 4 years from now.
there's no dispute that if this were written as a special permit and not a variance, that they wouldn't have a Cornell claim, because you can impose a special permit requirement, require them to go and put their application before the BSA, and BSA does the balancing test. And our point is the fact that it's a variance here and not a special permit makes no difference. That's form over substance. What the courts of appeals said in Union College case is that the variance available to Union College in Schenectady was the traditional variance where they had to show undue hardship or the burden was against them, was on them to prove it. And the court said that wouldn't provide the proper review that they're entitled to under Cornell. And what we're saying is if you look at how the BSA has consistently, time and again, handled educational institutions, variance applications, applying Cornell, it gives the exact same deferential review. And my friend has said, you know, looking at the factors, that NYU speculates that that's not going to be adequate, that it's going to be different. But the answer is they need to go in front of the BSA, seek a variance, and then they can come back to this court and you can evaluate what the BSA did and compare it to what the Court of Appeals said they're entitled to under Cornell. And then you'll have a ripe claim that properly framed for decision as to whether they're getting the kind of deferential review they're entitled to. At this point, it's speculation, and that's not the way that a facial challenge trying to strike down a zoning provision on its face for the future should be presented to you.
Thank you.
Thank you.
The standing issue in this case is very, very straightforward. NYU is in the business of educating students. It owns or leases 7 buildings, including buildings directly across the street from its main campus and directly adjacent to buildings that it already owns.
That doesn't determine standing. What determines standing is whether it's aggrieved by the adoption of this zoning regulation. And if they have to do something different because of this new zoning regulation that they didn't have to do before.
That is.
And so far, I haven't heard anything that, any way that it makes their lives different than it was before the zoning regulation.
With respect, Your Honor, the zoning standard, as explicated any number of times in the state of New York, is that, quote, and I'm quoting from your decision in Real Estate Board, quoting the New York Court of Appeals decision in Sunbright, is that owners of real property who are subjected to a zoning classification or other use restriction are, quote, presumptively affected by the change and therefore technically have standing to assert claims. The dissent in that case.
So let me just ask you this. If there wasn't that extra, if you weren't, there wasn't a carve out, would you be in a better position now to build your dorms or your classrooms than you would prior to the zoning change? So is that is what you're arguing is your injury, correct? You're not in a better position where you would be if you were treated like everybody else.
Yes, if we were treated like everybody else in this mixed zone district, we would not have to do, and you know, my friend points you to.
A word, and when you quoted from the Rebney case, it said owners of real property who are subjected to a new zoning classification. And it's not new as it affects you because you're in exactly the same position.
Your Honor.
You still have to, before you had to apply for a variance, now you have to apply for variance.
Your Honor, a
So it's not new in the way it impacts you.
I'll give you the example that we gave in our brief when we thought we needed to explain why Justice Leibowitz's analysis.
Stay away from gender classifications and racial classifications because those are not the same as NYU.
If the proposition here is that gender and what other kinds of classifications?
In your brief, the examples you used that I recall had to do with discrimination on gender, discrimination on race. So
Okay, I'll give you the example there. The standing case, Lujan. Lujan was a case in which the court was considering a restriction, a law that said that pretrial detention is available when the government shows that no release condition would protect the public. And because there are so many instances in which that could be shown, you don't have standing to challenge that. Instead, what the law said was that you can be detained pretrial for, anybody can be detained pretrial for any particular reason, of course there would be standing to challenge the facial validity of that, which is why the New York Court of Appeals has said over and over again that a variance, the possibility of getting a variance, does not defeat the standing of someone who claims that the legislative restriction itself violates the Constitution. And we have in this case, in any event, if one is looking at injury, there's the affidavit of Mr. Haas, which is in the record at page 2441, in which he explains in detail how NYU is injured every single time it needs to go through the process of figuring out how to allocate its resources to provide space for pedagogy without being able to use a building that is directly across the street from its main campus. And that is all that standing requires. My friend says that you have to show that the injury is imminent, but that is not a requirement in real estate zoning cases. That was the basis for the dissenting opinion in Real Estate Board, which instead relied on the Court of Appeals statement in Sunbrice and Douglaston and a few other cases that, quote, zoning litigation in particular should be resolved on the merits rather than by preclusive standing rules.
Thank you. Thank you both.
Thank you.
Board of Managers versus 56 and Park.
Good afternoon. May it please the court. Kevin Wallace for the appellant, 56th and Park, New York owner LLC. This is an appeal from a CPLR 3211 motion to dismiss a common law indemnification claim. The appellant is a sponsor of a condominium in Midtown. The plaintiff's underlying claim relates to design and construction defects, and they're seeking to contractually compel the sponsor to remediate those defects under the offering plan. The sponsor did not itself construct or design anything. Instead, we hired professionals to do that. We have sought to assert a third-party claim for common law indemnification against the respondents who were the structural and mechanical, electrical, plumbing engineers for the building. Those respondents are licensed professionals. They were the ones who actually performed the design. They signed and stamped the drawings with the DOB. The underlying allegations relate to issues identified in the report of SBI Consultants, which is the plaintiff's expert. On appeal, the respondents have asserted that they should not be subject to the claim because the plaintiff's underlying complaint does not expressly state that they're seeking to hold appellant vicariously liable for...
So I have a whole bunch of questions for you. So the allegations here are that the sponsor engaged in active wrongdoing because the sponsor did not abide by its representations in the offering plan, right? Is the offering plan in the record?
I don't believe the offering plan is in the record now.
So, okay. So, but the allegations are there, and let me ask you, here we have an extremely tall building, right? What I call a pencil building, and it's 101 stories tall or something like that. And part of the problems alleged have to do with the fact that when the temperature goes a certain way, the wind goes a certain way, the building is supposed to sway, and the elevators are cut during that period so that they don't bang the people around inside the elevators. Am I right so far?
Correct, and the building is designed to sway because with very tall buildings, you need to have some building movement. If it's static, it's not as safe.
Is there anything, I don't want to go outside the record. This is very difficult because the offering plan is obviously at issue here. The responsibilities of the sponsor are set forth in the offering plan, and so are the special risks that a shareholder or a unit owner could take into consideration before making a purchase. And my question, if I had if the record was sufficient, would be, was there anything set forth in the offering plan, in the special risk section even, that said that there were problems inherent in a building, perhaps inherent in a building this tall, with respect to services that have to be cut or will be impacted in the case of inclement weather?
The offering plan does have extensive disclosures. I don't know all of them specifically offhand. For purposes of this motion, since it's a 3211 motion, for the underlying claims, we do dispute many of the plaintiff's allegations, but they have alleged that there are design issues in the building. To the extent that they can prove that those are correct, we fully delegated exclusive responsibility for the structural engineering to WSP Cantor Cianuk and the exclusive responsibility for the MEP.
If you didn't abide by your unknown representations in the offering plan, can we really dismiss? Can we really, what do we do?
We allow for discovery. The plaintiffs have made certain allegations. We're currently undertaking discovery. Depositions are ongoing. They've made certain allegations concerning the structural engineering, which was designed by WSP Cantor Cianuk. They've made certain allegations concerning MEP engineering, which was designed by WSP Flack and Kurtz. Appellants, who are the sponsor, have sought to assert common law indemnification against those design professionals who we delegated that responsibility to. Under the First Department case 17, Vista Fee Associates versus Teachers Insurance and Annuity Association of America, the governing law is that in the construction context, to allege common law indemnification, a party must allege that it was compelled to discharge a duty that it fully delegated to another, and that the negligence of that other party was the actual cause for loss. Here we've alleged that we fully delegated the structural engineering to the structural engineer. We've alleged that we fully delegated the MEP engineering to the MEP engineer. We've alleged that to the extent the plaintiffs show that there were design defects related to those engineering services, that we're not responsible for those. We weren't the engineers of record. The respondents were the engineers of record, and if the plaintiff can prove the design defects, it would be as a result of the engineering services which were performed by the respondents.
Thank you.
Good afternoon, Your Honors. May it please the Court. Jamie Nardiello of Zetlin and De Chiara for the third-party defendant respondents, WSP Flack and Kurtz and WSP Cantor. The plaintiffs in this matter commenced this action against the sponsor because the sponsor represented to the condominium unit owners that this was an ultra-luxurious building and a world-class building. The plaintiffs allege a series of issues in the building, many of which they claim are the direct result of the affirmative acts of wrongdoing by the sponsor. The motion court properly dismissed the sponsor's claim of common law indemnification against the WSP defendants. The law in New York is clear that since the predicate of common law indemnity is vicarious liability without actual fault on the part of the proposed indemnity, a party who has itself participated to some degree in the wrongdoing cannot receive.
I'm going to stop you right there. Where is the offering plan, and where are all the amendments that would necessarily follow with the filing of an offering plan?
Your Honor, the allegations in the underlying complaint against the sponsor are enough. They demonstrate that the sponsor acted on its own affirmatively by a laundry list.
Counsel, let me just ask you, the plaintiff's claims are all based on contract, correct?
The plaintiff's claims were based on the offering plan. Yes,
Right.
Your Honor.
So breach of you said you were going to do this and you didn't do that. You said you were going to do that and you didn't do that. You said you were going to do that and you didn't do that,
Yes.
right? So there's no common law indemnification for breach of contract claims, right?
Exactly. Yes, Your Honor.
Okay.
So they're trying to pass that through to us when the allegations in the underlying complaint are that the sponsor scrimped on the finishes that were being installed in the building, that they cut corners, that they siphoned funds. And the cases in the First Department are clear that those types of claims are not appropriate for common law indemnification. Your Honors have no further questions. Thank you.
Thank you.
I'd like to briefly respond to 2 points. Justice Scarpello, to your point, in the construction context within the First Department, there are common law indemnification claims for contractual underlying breach of contract claims. I'm quoting from 17 Vista Fee Associates, 259 82nd 75. It's a First Department case. And I quote, that TIAA's underlying counterclaims sounded in breach of contract rather than tort does not defeat the indemnity claim.
Because the common law indemnity claim?
The common law indemnity claim.
In what context would you have common law indemnity on a breach of contract claim? It has to do with negligence.
So there are other cases.
Is there any negligence claims between the plaintiff and the defendant?
The plaintiff's underlying claims are that there were defective design and defective
Breach
construction.
of contract. You promised me I was going to get this and I didn't get that, right?
Correct.
That's the only way you could. The plaintiff has no duty to the defendants, right? The plaintiff has a contractual obligation.
So
The only obligation it has comes out of its contracts.
in the construction context within the First Department, there's numerous cases that state even common law indemnity can be premised on contractual claims. And we cite to numerous cases in our brief. And I quoted from one a minute ago, which was 17 Vista. There are others.
That's not what the claim is here. The claim is that it was a breach of contract, failure to uphold the contractual obligations under the offering plan, which we don't have a copy of. There is nothing here. The plaintiff's claim is not in any way based upon negligence.
So the plaintiff's claim in 17 Vista was that a smoke purge system was designed effectively, and that breached the seller's contract to the purchaser. The seller brought a third-party common law indemnification claim against its design professional there, which was affirmed by the First Department. Because in the construction context, breach of contract claims are oftentimes brought due to the negligence of third-party professionals who the plaintiff is not in privity with, and they assert breach of contract claims against the seller or the condominium sponsor.
But this is specifically, there's no allegation as to negligence by WSP.
There is within the SBI report. Numerous of the items relate to...
In terms of its claims, it has no claims of negligence against the defendants. So there's nothing to indemnify in terms of negligence claims.
Respectfully, the SBI report includes claims of negligent design based on the design undertaken by the WSP defendants.
So you're saying there are negligent claims?
I'm sorry. Are there any legal claims based on negligence?
Their claims are based on breach of contract, but again, there's multiple First Department cases that state within the construction contracts the tort breach of contract distinction does not matter.
Thank you. NASA versus Macy's, Inc.
May it please the court, your honors. I know it's been a long day. My name is Scott Singer. I represent the plaintiff appellant in this matter. Yeah, put it down a bit. On a prior appeal, this court held that there was a question of fact as to whether labor law section 200 was violated based upon a defective or dangerous condition of the A-frame cart the plaintiff was pushing at the time of his accident. Then at the close of the evidence of the trial, Supreme Court held there was a question of fact as to whether labor law section 200 was violated, again citing conflicting evidence as to whether structure tone, the general contractor, created the dangerous condition by providing plaintiff with a defective A-frame cart and whether the cart was in fact defective. And then at the trial, at the conclusion of the trial, the jury returned a verdict based upon that same allegation, or at least in part based on that.
What was what evidence was produced that there was notice of the alleged
The
bad
evidence
cart?
of notice stemmed from the fact that the plaintiff knew this laborer that provided it. He saw him every single day.
No, that has nothing to do with the cart. What evidence was it that the defendant knew or had constructive notice that the cart was defective?
They had constructive notice because that was their cart, and they were presumably using that cart all the time, and it was a regular.
What was the constructive? What was the constructive notice?
The constructive notice that they had a cart, they knew what the proper use of the cart was, and nonetheless they gave this
What was the
cart.
constructive notice that there was any defect with the cart?
Constructive notice is presumed from the situation that they were in.
Testimony was that the cart looked good, it functioned normally, no complaints about the cart.
It only
Plaintiff testified that the wheel was not visibly defective. He only noticed it when it wobbled after he put
Great deal of weight.
a great deal of weight, 400 pounds on the cart.
That's the constructive notice stems from the fact that they were using it presumably for lighter loads. And when it was.
And was there any evidence in the record with them when they were using it, there was a problem with the wheels?
There was no evidence.
So again,
recorded
what's
about
the
it,
constructive notice that there's a problem with the cart?
because they should have known, they did know what the rate restrictions were, what the proper use of it was, and they knew what plaintiff was going to use this cart for, and they nonetheless provided it to him.
Was there anything in the record about that? About the fact that when you put less than 400 pounds, there wasn't an issue with the cart?
Well, empirically, when he was pushing the cart, it was no problem. When he loaded the cart.
I don't know that that's an empirical conclusion. I'm not sure how you draw that conclusion. 400 pounds, the cart wobbles, but 399, it doesn't wobble. I'm not clear as to the constructive notice.
I think the labor the provider was aware of the use was going to be, and it was unsafe for that use. I want to turn a bit to the other.
I'm sure you do.
To the other claim that we've made. Now, there was this court, when it considered this case initially, did not specifically consider the angle at which the ramp was positioned.
Yeah, but that was never asserted. The plaintiff never had an issue with the ramp. He had an issue with the cart. The ramp, the whole issue of the ramp was never raised.
We actually, in the first case, we asserted a violation of 23.1.22 based upon the fact that the cart was narrow, and there was also testimony at the trial that...
Was that submitted to the jury?
Yes, it was.
That there was a problem with the ramp?
What was submitted to the jury was the question of whether Labor Law Section 200 was violated. And the plaintiff's testimony was pretty clear on that point.
Was the language dangerous condition, or was it ramp versus cart? The verdict sheet.
Presumably the combination of the ramp and the cart and the way it had to be pushed.
Did the verdict sheet say the ramp and the cart?
No, it just says whether Labor Law 200 was violated. Generally, it doesn't go into carts or ramps or anything else. And plaintiff's testimony was that because of the ramp was on a slant, we couldn't went straight because it wouldn't allow us to go straight. We had to pull to the right, to the left, when we were running the cart. So it's hard
again, plaintiff testified that the injuries were caused because of the cart and not because of the ramp.
Well, the problem with the cart wouldn't have resulted except that he had to pivot the cart toward the left.
Did he testify that the ramp had anything to do with his accident?
That was just his testimony.
That what? That the ramp caused his accident?
Positioning of the ramp, because of the ramp was on a slant.
That of course, that the ramp was defective in any way. Did he testify that the ramp was defective in any way?
He testified that it was positioned at a slant, and that's what caused the problem.
That's what a ramp is. right?
Yeah, I thought a ramp was at a slant.
No.
Because I think if you have a straight ramp, it's not a ramp.
Right? So that's what a ramp is.
It's
I'm
the ramp
asking you-
the plane of the ramp is at an angle in connection with the sidewalk. It's not straight with the sidewalk.
Yes,
He had to
that-
pivot it to
You're
get
saying
it
that
up.
it's slanted to one side is what you're now stating, but plaintiff never made plaintiff always said that it was the cart which caused his injury and not the slanting or any slanting of the ramp. And then plaintiff's expert, I don't think even made any opined about the ramp causing plaintiff's injury. I don't even know the plaintiff's expert was even asked about it.
No, he clearly did not testify. He was not permitted to. He didn't address it in his statement. Nonetheless, the plaintiff said, and I think this is very clear, because the ramp was on a slant, we couldn't went straight because it wouldn't allow us to go straight. He's talking about it was at an angle with respect to the sidewalk, and they couldn't, because of the way, they had to push it up. They couldn't push it and get it on the
But
ramp.
how does that make the ramp defective? That's what a ramp is, right? How is, because the fact that you have to push something up a ramp doesn't make the ramp defective,
Okay,
right?
Not because they had to push it up, but because they had to pivot it while they were pushing it up. That was the problem.
Again, how does that make the ramp defective?
Well, somebody had to place the ramp in that position, and that ramp, that position is what caused the dangerous condition at the
I
road.
just went through your proposed jury.
Wouldn't you need an expert to determine that, we have many of these kind of cases, the design and construction of the ramp contributed to causing the accident. If you're arguing that it was angled in a serpentine way that caused them to pivot, using your words, and that created that whole imbalance with the cart,
I think
someone, just bear with me.
Sorry.
Someone would have to make a record of that and say, yes, this was not designed appropriately, and it was a substantial factor in causing the accident. As I understand on this record, what was being presented to the jury was that this cart was defective. And if the cart was defective because of the wheel wobbling because of the weight, that's what the jury heard. And so now we have to consider, okay, maybe it was a defective cart. Where was the constructive notice on behalf of Structure Tone to be on the hook for that very defect that just surfaced for the very first time, because there's nothing else on this record that suggests otherwise, until this plaintiff put 400 pounds of I forgot what it's called, that cement or whatever, thinset or whatever, on that car. Where was the constructive notice as a matter of law? That's what happened here. The judge, pursuant to CPLR 4404, set aside the verdict because as a matter of law, you didn't meet your burden in establishing that Structure Tone was on the hook because of actual constructive notice. Did I miss something here, sir?
Justice Shulman, I really believe that this is something that any person can deduce from common sense. If you have to push it up at a certain velocity to get it up a ramp, it's very difficult to pivot it at the same time. And this is what was,
But if your claim is that it's the ramp that's defective, you have to allege that somewhere.
Not only do you have to allege it, but again, the expert has to, again, someone has to testify as to how the ramp was defective and how it also led to or caused the injuries.
I mean, I just went through the whole proposed verdict, your whole proposed verdict sheet, and there's nothing about ramps. You would think that if you were claiming that the ramp was defective, that you would have asked the jury to find that.
It was a dangerous workplace because of the position of the ramp. That's subsumed under that question, which is what the jury was.
Thank you.
Thank you, Your Honor.
May it please the court, Eric Leiter of Morrow Lilling Naparty for the defendant respondents, Macy's Inc. and Structure Tone Inc.
Let me just ask you a question. Did the plaintiff, when using his own thing, go up that ramp?
The plaintiff used the yellow A-frame cart. His accident happened before the wheel in question even reached the A-frame cart.
No, but and had the plaintiff used that ramp with the plaintiff's own cart before that?
So yes, Your Honor. In fact,
So there was nothing about the ramp when the plaintiff was using his own, right?
More
Is
than
there
that,
any testimony about the ramp being being wrong with the ramp?
there's not only no testimony asserting that the ramp was defective anyway, there was affirmatively an argument made in summation by plaintiff's counsel that there had to be a problem wrong with the wheel because he had gone up and down this ramp so many times with no problems that what else could explain it?
So the slant of the ramp was never plaintiff's argument.
Right. There was a point early in the case where they suggested they might try to make that argument. And the issue came up of whether or not they even could be permitted to, because when the defendants moved for summary judgment, the plaintiff's claims under Labor Law 200 and common law negligence were dismissed entirely as against Macy's, which would include the ramp, since this is the ramp going into Macy's. And because that had been
It's
dismissed...
not even Structure Tone's ramp.
Right, Structure Tone is the general contractor. It's the property... The property is Macy's property, and so the fact, I don't think there's any way plaintiff could explain, how could you have this claim as a common law negligence claim against Structure Tone, but not the property owner Macy's? And the claim as against Macy's was dismissed entirely before the trial, and this court's prior decision held that what was left of the Labor Law 200 and common law negligence claim was purely relating to this cart, that there was a dispute as to who owned it, but then that the defendants were on a summary judgment motion would have the affirmative burden of showing the absence of notice, that this court found they did not establish that, but at trial, it then became the plaintiff's burden to prove notice. And here, the trial court...
Was there any evidence about notice of the wobbly wheel?
No, none at all. And the trial court found the same thing that plaintiff's own expert, Nicholas Belizzi, found, and that's at page 623 of the appendix, where he's asked specifically, even if there is a defect, for how long of a period was that defect there? And his answer was, I would have no way of knowing. And he was asked that question again. So this could have happened when they loaded the thin set on. And his response, again, I have no knowledge of when the wheel became defective, so the answer is I don't know. He's conceding there is no notice that...
And did the plaintiff complain about this wheelbarrow, A-frame prior to the accident?
No complaints prior to the accident.
And there was testimony that no one complained about it prior to the accident.
Correct. His best friend, who was his foreman at the site, acknowledged he was standing only 10 to 15 feet away when the plaintiff first took the cart, that he watched him wheel the cart away, that there was nothing wrong with it. He saw nothing wrong with it. If there had been anything wrong with it at all, he would have stopped him from using it, that the plaintiff made no complaints to him. The first time there's a complaint is after he claims he's had accidents. And there's even the co-worker, Jimmy Gonzalez, who was within 3 feet of him throughout this whole time, and he was not called as a witness, and the plaintiff acknowledged that Jimmy Gonzalez had no awareness of there being any problem with the cart, or the plaintiff even having his first accident. So it's clear that the only way the jury could have come to the conclusion that they did on the Labor Law 200 claim was because the plaintiff's expert suggested to the jury that there is a strict liability standard on general contractors, that they're liable. His testimony was that they're ultimately liable for all safety. And the question that was on the verdict sheet, I think in the context of what they heard from Mr. Belizzi, I think led them to believe that, as he had asserted, that if there's an accident, therefore the safety must have been inadequate. And I'll just read the question that was given to the jury, if I may, I see that I do have the light, though. Did Structure Tone, Inc., as contractor in charge of the project, violate Section 200 of the Labor Law with regard to the plaintiff's first accident on July 20th, 2013, by failing to provide and maintain a safe place to work with adequate protection for the safety of all persons employed therein? And I believe that the jury took that as putting a strict liability standard on them because Mr. Belizzi specifically made those arguments in his testimony.
Thank you.
Thank you, Your Honors.
I don't think there's any question that our contentions with respect to the ramp are within the purview of that question. Now, I just want to emphasize, it's always been, the questions about the sufficiency or adequacy of the ramp have always been in the case. They were in the case when it first went to the Appellate Division, and the court, for reasons that are not entirely clear to me, rejected plaintiff's contention that because the ramp was too narrow, it was a violation of Section 23-1.22. Now, at the beginning of this...
But it's not Structure Tone's ramp. So how are you gonna put liability on Structure Tone for a ramp that it wasn't its ramp?
We don't know they don't know, and we don't know who put the ramp in, but we do know...
Well, it's your burden to say whether it's Structure Tone's ramp or not, right?
Your Honor, Structure Tone was in charge of the site, and they clearly knew where the ramp was and how it was constructed. Their testimony, Michael Sansone, their witness, said, yes, I knew there was a ramp there. I knew it was, there was a metal ramp and so on. They knew about it. Macy's didn't know about it. That's why we didn't make a claim against them. We took the general contractor in charge of the site. They should have known that this was dangerous. Now, as I said, the ramp has always been in the case.
Present something that Structure Tone was responsible for the ramp, that Structure Tone constructed the ramp or put the ramp there? I'm not understanding.
They're the general contractor. They're in charge of the site.
So what? I mean, why does it have to have been Structure Tone or the GC that constructed the ramp?
That's the way Labor Law Section 200 has always been understood. It is a duty on the part of an owner and the part of a general contractor.
So was there anything in the record that the ramp was placed there once Structure Tone began its work at the site?
There's no testimony about when or who constructed the ramp.
What is the connection? What connection is there with the ramp to Structure Tone, other than he was using the ramp?
That's what the obligation of providing a safe place to work is. It's the general contractor. It's their responsibility to provide a safe place to work. This is Combs against the state. This goes back for decades. That's been the law. It's the general contractor's responsibility. And at the beginning of the case, the specific claim about the position of the ramp was raised. The court said it was not contrary to this court's appellate division decision. So it was properly in the case, and it was properly a basis for the...
Thank you both. Flowers v. 73rd Townhouse, LLC.
Good afternoon, Your Honors. Mark Goldie for Appellant J. Christopher Flowers, my colleague, Mr. Moldovsky. And thank you for permitting us the opportunity to argue this non-enumerated appeal. Presumably there is something on your minds. I hope that it is the fact that disclosure of the respondent's financial records was ordered in 2013 and 2014 and again in 2015 and again in 2017.
Counsel, being familiar with the history and the facts here, and there have been...
So this is now Flowers 5.
Flowers 5.
And I don't know how I was not on any of the previous Flowers cases. I don't know how that happened. But this is now Flowers 5.
So in Flowers 5 now, essentially what you're seeking on appeal is discovery damages. In other words, the lack of cooperation on the part of the defendant in giving everything you needed with respect to your claim against them, with respect to the property. And what I have to wrap my head around is that when you filed your note of issue, and that's really central here, you didn't reserve any rights. You didn't say, okay, I'm filing a note of issue because the court is imposing a standard and goal and I want to be ready for trial. But by the way, I reserve my right to be able to seek sanctions and legal fees because of the schlepping and not giving everything that we needed with respect to being ready for trial. Your whole gestalt here. So what I'm trying to understand, how can you now come and say, I want sanctions, discovery sanctions, when you basically were silent when you filed your note of issue? How did that not constitute a waiver as a matter of law?
The answer is twofold. First, none of the statutes or rules under which we're moving really require that. Certainly, maybe one does in some parts of the state, but not in Manhattan. And secondly, this isn't really a discovery sanction.
Well, you moved under 3126, which is a discovery sanction, right?
Yes,
so that is a discovery. And we have case law in this department that says once you file the note of issue, you've waived any right to dispute the discovery that you got, how you got it, when you got it. It's all waived.
That is a debatable point.
Well, no, I'll give you a
case. That is a what point? I'm sorry.
No, I believe it's a debatable point.
I've got a case.
Counsel, I can tell you, Marte in 2013, Rivera in 2010, they said discovery sanctions are inappropriate where plaintiff waived further disclosure by filing a note of issue representing that all discovery was completed and there were no outstanding discovery requests.
I understand. There are many cases discussing 3126.
That's what you're moving under, and it says you've waived your right to get discovery sanctions once you file the note of issue.
It is only one provision that we moved under, But I want to return to 3126 because it's your interest. Most of those cases involve a preclusion or some sort of, as we call it, a discovery sanction.
The sanction doesn't matter. Why? It doesn't matter. The sanction matters not, because striking the pleading would certainly be more harmful to the party against whom the discovery sanction is being issued against than paying $5,000. So I don't buy the argument that because we're asking for money rather than a more draconian sanction, that those cases don't apply.
I understand.
All right, so let's go to the frivolous argument, the argument that there should be sanctions for frivolous litigation.
Certainly. Well, the frivolity here is a pattern of delay. It was designed to drag out this case and raise Mr. Flowers' attorney's fees. The motivation for this was the prior case back in 2004. And the way it was done was to simply never meet a deadline, never attend a scheduled, whatever it would happen to be, deposition, and to just kick the can down the road indefinitely. And you're adding to that, I mean, you see in the brief, there's all these emails. We need to schedule a deposition. I need a date. I need a date that you won't cancel. And this goes on for months and months and months. And there's much, much more of this. The other critical thing is the death of Daniel Kingsford, which became something of a crisis.
That was bad, and your adversaries were slapped $7,500. But what you want is money basically to cover the forensic accountant more than anything else, right?
That's correct. The check that Mr. Kingsford supposedly wrote, which in fact it turns out he didn't, for $340,000 that came within the statute of limitations period that would have prevented Justice Feinman from dismissing the case in the first place back in 2010, was never produced because the respondents' counsel weren't speaking to their client. I don't know how to say it, wasn't really their client. It's kind of inconceivable that Mrs. Kingsford would call my colleague and say, I don't have a lawyer, I don't know what you're talking about, I'd really like you to tell me who this is.
So you made a motion for sanctions in 2014, which was denied, correct?
Yes.
Did you ever appeal that?
No, we
Did you ever, right. So, and the next time we hear about it is 4 years later, right? In 2018.
Yes.
4 years of nothing. And now you're saying to us, go back to the period between 2014 and 2018?
I don't think that's really what is dispositive. I mean, what happened in chronological order, what happened was the accountant was finally deposed in the summer of 2017. And he said, oh yeah, here's a stack of documents that were never produced. And our accountant looked at them and said, now I have to redo my work. And also, these are incomplete and I don't really understand them. And as part of the deposition, the accountant said, there's this woman named Jane who works at the respondent's office. That's where I get them from. She knows what they are. So 6 months later, we finally get to depose Jane. And this is now a month after the accountant has finished his forensic accounting report, upon which fraudulent conveyance was found, and submitted it following the scheduling order. And Jane says, oh yeah, those documents you're looking for, those financial records, they're on the computer in my office. I could print them off. It would take 15 minutes.
Thank you. Your time on rebuttal.
Thank you.
May it please the court, Ted Donovan, Goldberg, Wepper, Finkel, Goldstein for the respondent. The questions you just asked, I think, focus on the main issue here. This is too late a motion. They never reserved their rights.
Under 3126, but what about frivolous litigation? What about all the motions they had to make because you didn't produce documents?
Every time we asked for more time, they consented. These were all done by stipulations. And if you look carefully at the actual papers, you'll see that what would happen is we would agree on a new date, and then before the date even came, they're making a motion to compel. And now they're saying, oh, we had to make a motion to compel. We had a stipulation. If they were saying that we were dragging our feet, all they had to do was say, no, we're not going to consent to your request. You can't prove by clear and convincing evidence that we were acting frivolously and were intentionally dragging things out when they were consenting to our requests.
Except
If
for
they
the
had
one
said, "No, this is taking
situation,
too long,
right?
We can't do this anymore," that would be different.
Except to the one situation.
trouble hearing, I'm
Except to the one situation which you were sanctioned for, which was not telling the court about the death of the party.
Yeah,
right?
and that was clearly,
You're not cross-appealing that.
I'm not cross-appealing that. We paid the sanction. They were absolutely right. The thing is, this is a family business. And then there's the Kingsfords, who were non-family members, who were very minor participants in the project. And it was always agreed that the family would be representing the Kingsfords. The family would pay whatever the Kingsfords had to pay. And so all of our dealings were directly with the family. And there was a breakdown in communications between us and the Kingsfords. And that shouldn't have happened. And we were sanctioned, and we paid it immediately. We do not protest that, and we apologize to the court. We apologize to counsel. Thank you.
Thank you.
While I understand the court's focus on Rule 3126, there is nothing in Rule 130 or the contempt statute that requires a motion for sanctions to be made at any particular time if it happens to concern discovery or if a note of issue has been.
Yeah, but it should be made relatively soon after the event. I mean, we're talking a couple of years, right?
Yes and no. I mean, certainly, we will all agree that the discovery phase of litigation should be concluded and we should move on. Unfortunately, practice in the trial court does not work that way. It takes a year to get a motion resolved. The idea that should make another motion and say, no more consent, I'm just going to make a motion and wait for the court to rule and wait a year, that's not, I mean, you've been on the trial court, Your Honor. You know how it works. Consent is imposed either by the court or by practicality. And as far as it being 4 years, it's really not 4 years. That what prompted this was Jane, the bookkeeper, saying, oh yeah, all those records are on my computer. Now, we filed our summary judgment motion, and we filed the note of issue. We filed a summary judgment motion a few months later and got the sanctions motion in shortly thereafter. You know, we're a small shop. We do things as best we can. The fact is, when you start looking at the conduct, you say, you know what, this really goes back to the very, very beginning. When you look at its supplemental record, pages 90 and 91, where Mr. Kingsford, one of the principals, says to the accountant, we put back money in July 2007, which is within the statute of limitations period. I don't want to revisit the whole motion to dismiss. And there's $500,000 remaining to be distributed in the case. And so, you know, if Justice Feynman had seen that, he couldn't possibly have dismissed the case on statute of limitations grounds. He would have said, I don't know what this means. You got to tell me. And you start to say, you know what? This goes back to the very beginning of the case, and it's unacceptable. The court system can't function when litigants are free to do as they please and say, oh, well, you know, you consented to it, or I already produced everything, I already told you that. I mean, there's a lot of detail like this. I want to give you one quick example because I think it's very pertinent. In the record, the supplemental record, pages 145 to 180, the 2006 tax return of 73rd Townhouse LLC. Now, if you walk that back into the affidavit of James Rinsler and then into the brief, he starts with, we respondents produced these documents in 2006. You already had them from the very beginning and you knew everything. When you go into the affidavit, it actually is a little more subtle. It says the 2007 return was produced in 2013 in response to a discovery request. And here, by the way, is the 2006 return. So they're being careful not to make a misstatement there. The first 5 pages of that document and the last 13 pages were never produced in discovery. They just never produced. They appear for the first time in this case in response to a motion for sanctions. So yes, I will concede, you know, knowing what we know now, we should have made a motion for sanctions earlier. I don't think Justice Bannon would have granted it. She would have denied it as moot or something.
Thank you. Thank you both.
Thank you. You too. Ted, are you well? I hope.
You know, with all the slurs on my character, I cannot be your friend.